wants to be heard, I guess that I will come off the mute. I would be shocked.
Judge David Wolf presiding. All ye having business before this court, for all 90 shall be heard. God bless the United States, this state, and this court. You may be seated.
All right, good morning. We're going to go ahead and start with a call of the docket. First case on the docket is State of Tennessee versus Jonah O'Neill Allen.
Thank you, Your Honor. Good morning. This is Mr. Jonah Allen. His case is set for a probation violation hearing today. He's got a case in Hickman County that's in Bindover. We'd ask to reset this to the September VOP date, please.
What is that day? I could look on my own calendar. All right, reset for September 30th.
Thank you, Your Honor.
Do we have inmates up here already?
Oh, yeah, Judge.
2025 CR 162, State versus Christopher Aaron Carson. This is apparently the attorney is Sunny Stevens. She's running late. She had to be somewhere else.
I'm confused, Your Honor, because I have Mr. Carson, but his case is actually on the June docket, what I was tracking. Is Ms. Stevens also, or has she been retained?
What is that about? Oh, okay.
No.
Got it. Well, we have him, when she arrives, we'll deal with it, but. (2022) CR 468, State versus Tyler J. Chambers. Tyler Chambers for violation of probation hearing.
Your Honor, Mr. Chambers has some pending charges. I think we've got him set on the new charges in September, Your Honor. I think that's is it the 23rd date? I think September 23, Your Honor, is the date we have the other charges set. My thought is if we can put this VOP on the same day as those other charges, we can get them all.
So do you want to put it on September the 23rd or the 30th, which is VOP day?
Thank you, Your Honor. September 23, please.
September 23.
Your Honor, I apologize. May we please have September 8 to put all of his cases together?
All right, September the 8th instead of the 23rd.
Thank you, Your Honor.
All right. Do we know if Mr. Chambers is in custody somewhere else? And do we have, excuse me, do we have any of these people that are here on Zoom for the jail? Okay. When you have inmates arrive, let me know and we'll take them up. We'll move to page 5. 2026 CR 148, State versus Ray Osro Dorman.
Your Honor, Mr. Dorman is also in custody, I believe. His is a plea by information. So once he arrives, we'll be ready to take that up,
All
Your
right.
Honor.
He's in Dickson jail?
Yes, sir, he is.
Okay. If you will add him to the list, please. 2025 CR 256, State versus Rodrigo Flores. Mr. Baker's case.
I haven't seen Mr. Baker yet.
That was one where we were wanting to see about if we were going to reach a settlement agreement today or not, so I would ask the second call it.
Put it on the second call.
Yes, sir.
2024 CR 192, State versus Danielle Lee Spicer Generizio. Restitution hearing.
Yes, Your Honor. General Wojnarowski and I have settled that. We're going to submit an agreed order
All right.
to
An
resolve
agreed order
that.
will be submitted.
Thank you, Your Honor.
Thank
And
you.
Ms. Generazio is present. May she leave, Your Honor?
She can leave. All right. 2024 CR 242, State versus Ryan Hale Sr. Mr. Talbot's motion to sever defendants.
Judge, the co-defendant pled last court date, so I'd say the motion to sever is moot at this point.
We will,
I'd like to get another status date, but Mr. Talbot may want to be here for that.
well, as soon as Mr. Talbot comes back in, we'll take it back up. Have a seat. 2022 CR 26, State versus Sabrina Ann Hipshire. This is the public defender.
Judge, on Ms. Hipshire's case, she has a violation of probation. To resolve this, she is going to admit the violation of probation. She'll waive her hearing. She'll be reinstated to supervised probation with in-person reporting only. And she has, I've reviewed this with her. You can date there and sign there. Today's the 27th of May. All right, thank you.
Ms. Hipshire, raise your right hand. Let's place you under oath.
Yes.
State your full name for the record.
Sabrina Ann Hipshire.
Ms. Hipshire, you're here on a violation of probation. You have the right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation. Do you understand that?
Yes.
Do you understand you would have the right to have a lawyer and have one appointed if you could not afford your own, as we've done with the public defender?
Yes.
Do you understand if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes.
Do you understand that by pleading guilty, you're waiving that hearing and you're waiving the right to appeal?
Yes.
You understand I'm going to approve what your lawyer and the state have agreed upon, which is to reinstate you to probation, but you're going to be required to do in-person reporting only, and this is your one last chance to successfully complete your probation. Do you understand
Yes.
that? You understand everything I've explained to you?
Yes, sir.
Do you wish to plead guilty according to this agreement?
Yes.
And upon your plea of guilty to violation of your probation, I find that you should be revoked to serve your sentence. However, by agreement with the state and your lawyer, I will reinstate you to supervised probation, but require that you be in-person reporting only. Make sure you know who your probation officer is and stay with them, okay?
Yes, sir. Thank you.
2024, Mr. Talbot, I had Ryan Hale Sr., and it was your motion to sever defendants, but General tells me that the defendant, co-defendant pled the other day, so it renders your motion to sever defendants moot, I would think.
It does.
All right. Do we have a status day on it?
I think that we had one earlier this month, Your Honor, and the case was reset to today. So if we can go to the status
September
date,
8th.
September. Thank you, Your Honor.
That'll be the final status day. You can either plead that day or go set a trial date.
Yes, Your Honor.
2024 CR 247 State versus Dalton Ray Hooper. That's Mr. Flanagan's case. Anybody heard from him today? Who's what?
I think he's just shocked you're on time.
Normally you were up and moving around a little bit. I just wasn't sure. So that's what I was afraid of. All right, we'll put it on the second call. You need to be a little bit more assertive in your old age. So 2023 CR 169 State versus Jeremy J. Jaco. Mr. Sanders. Anybody heard from Mr. Sanders? He's not in the box, right? Put it on the second call. Twenty 25 CR 131 State versus Kevin Nilish Kesaria. It's the Hall Brothers Bonding Company's petition for extension of the final bond forfeiture. Anyone here from Hall Bonding Company? Hall Brothers Bonding? All right. I don't know. Scott Hall. Just move this to, he hasn't appeared, in my opinion. If he wants an extension, he needs to appear. Just put it on the next criminal docket call for whoever the next judge is. Let him know he needs to be here to argue it. 2020 CR 185, State versus Stephen P. Lane. Mr. Bell Myers.
Yes, Judge, I actually spoke to Mr. Bell Myers and then also have been speaking to Mr. Baker, who's been speaking to Mr. Lane. We're close to a resolution on the criminal case as well as a civil case, and we asked to put it on June 15th for status.
June 15th.
Yes, Judge.
All right. so
I think that's
15th.
Judge Wallace's bail day.
All right. June 15th. On page 14. Well, we can put it on June 15th, but it's because Mr. Lane, it's a motion for new trial, which I heard the trial, so I would have to hear the motion for new trial. Oh,
Home improvement / theft case in which you
that's
granted
true.
one. So
Since I
we're-
granted a motion for new trial, then we start over from scratch.
And I think it's just a date so we can at least make a resolution, Judge.
All right, that's fine. 2024 CR 100, State versus Natasha Nicole Smith McCoy. Mr. Spratt.
Robertson County, there was no hold placed on her based on your Honor's order. But we did enter an agreed order for her to go into custody. I have not spoken with her in about a week.
So she's supposed to be here today or be in custody, is that correct?
Supposed to be in custody. You revoked her bond.
Will we have a capias out there for her then?
She's taken into custody that day. Robertson County on a violation of probation.
Issue a capias for her. Hold for hearing. Twenty 2024 CR 67, State versus Charles McDonald, Mr. Wainick's case. Let me guess, he's at court somewhere else. Anybody heard from Mr. Wainick? We'll put him on the second call. 2022 CR 379, State versus Kevin James Moran, Mr. Flanagan.
I haven't heard from him forever, so.
April the 17th, he announced.
Oh, okay. Not good taste, if nothing else.
All right, Mr. Moran is not here. Mr. Flanagan, you've obviously not been hired to represent him. Issue a capias for Mr. Moran to hold for hearing.
I'm gonna try to call him on the break.
Do you know him? All right, well, we're going to still stand on the capias. Yes. So has he got a bond? A release on recognizance. So that's revoked. Issue a capias. All right. 2021 CR 365, State versus Joey Adarez Nixon. This is for payment status. I do have an amended violation of probation warrant that was issued on May 14th of this year. Mr. Nixon, it's alleged on this amended violation that you were convicted of theft on or about the 18th day of November 2022 and sentenced to 2 years in Tennessee Department of Corrections. It is alleged that you have violated Rule 1 in that you were arrested in Williamson County and charged with unlawful carrying or possession of a weapon and shoplifting or theft of property. And that also violates Rule 3 of your probation. Because of this, you have the right to have an attorney represent you, because if those are the facts, then you very well may be looking at your sentence being revoked. Do you wish to have a lawyer represent you?
I do.
Are you planning to hire a lawyer of your own?
Yes, sir.
All right. What is the June VOP day? All right. You'll be served with this amended violation of probation. There's a bond of $2,500 that you'll be required to make. That's, I judge whoever that was that issued the warrant. I can't read his signature. Is that Turnbow? Judge Turnbow has set a bond of $2,500, so you'll be in custody until you make that bond.
I've already did that, Your Honor.
You've already done that?
Yes, sir.
Good. We'll see you on June what? June 29th is when you need to be back with your lawyer.
Okay,
All right, thank you.
thank you.
Show he's been arraigned. Give him a copy. Mr. Nixon, let's give you a copy of this new amended warrant if you don't already have one. And you need to give that to your lawyer that you hire. All right. Well, that's a copy you can have. All right, that's fine. He has a bond, so he'll be released. 2024 CR 67, State versus Anthony Nathaniel Thompson. Mr. Webb's case. We get a new trial date. This is on the conspiracy of possession of methamphetamine over 300 grams. Is this one of the ones that we already have a trial date on? Do we have any of the inmates here yet? The what? Yeah. I'll put it on the second call. Mr. Flanagan, we have State versus Thomas Adam Zurowick. All right. Then we're ready to take up the females. Bring out the first one, please. You may. Mr. Talbot?
Thank you, Your Honor. This is Ms. Tiara Bethke. She's here on a probation violation. There's been some negotiation. I have one settlement offer that I'd like to discuss with her, so if we may second call this, I'd like to meet with her.
All
and
right,
see if
I'll
we
put
get
it on
this
second
resolved.
call.
Thank you, Your Honor.
Okay. These are on the Zoom. Public Defender represents Ms. Blackwelder.
Yes, Your Honor. This is going to be a hearing, Your Honor. I'm just working out with the state what violations Ms. Blackwelder will admit. Can we proceed on the? We do think at least we would like to be heard on disposition, please.
All right, so are we having a full hearing on whether or not she's violated her probation as well as on disposition, or is she?
No, sir. We're going to proceed just on admitting a violation, and that should be heard on disposition.
All right. Ms. Blackwelder, if you'll raise your right hand, let's place you under oath. Thank you. State your full name for the record.
Emma Lawson Blackwelder.
Ms. Blackwelder, you're here on a violation of probation. I want to make sure you understand your rights. Do you understand you have a right to plead not guilty and to have a hearing where the state would be required to prove that you had actually violated your probation, and they would have to meet the legal standard?
Yes, Your Honor.
You understand if we had that hearing, you would have the right to have a lawyer and have one appointed, as I've done with a public defender?
Yes, Your Honor.
Do you understand if we had the hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals? Now, by pleading guilty, you're waiving your right to contest the issue of whether you are guilty or not guilty of violating your probation. Do you understand that? But you are preserving the right to have a hearing on what should happen to you, more or less. You understand that? You understand that if we have that hearing on the sentencing portion, then whatever I do, you can still appeal what my decision would be and have a lawyer help you with an appeal to the Court of Criminal Appeals. You understand everything I've explained?
Yes,
You want to go ahead and enter a plea of guilty to the charge of violating your probation? All right,
If
and I
I
find
may-
she's guilty, but we'll go ahead and put on the proof about the disposition.
Thank you, Your Honor. And she's signing a plea sheet here, which admits her violation. And specifically, it's the new convictions out of Madison County, Tennessee. Those are in the first amended petition. She's admitting those violations only. But you're gonna sit next to me.
All right, you want to call her as a witness?
Yes, please, Your
You'll
Honor.
come around, please, ma'am. You've already been sworn, so just have a seat. Change this.
Would you please state your name, ma'am?
Emma Lawson Blackwelder.
Okay. And you've admitted that you're in violation of your probation, right?
Yes.
And that's because of new convictions?
Yes.
Okay. What were those convictions?
Like the
In Madison County?
simple possession, paraphernalia, and theft.
Okay. And were you sentenced to probation on those?
1129,
Okay.
misdemeanor probation.
Okay. And are you asking the court to reinstate you to probation today?
Yes.
Okay. How much time have you spent in jail on this
For
arrest?
4.5 months.
Okay. And is this your first probation violation?
Yes.
Okay. When were you originally put on probation?
In 2022.
Okay. And if you were reinstated to probation, do you know where you would live?
Yes, I have a bed waiting for me at Archangel's Recovery Community House in Charlotte.
In Charlotte, Tennessee, is that right?
Yes.
Okay. And how long would you expect to be there?
I can stay up to 2 years there.
Okay. So you got new convictions. What was the circumstances of those convictions in Madison County?
They just read it at 1129, run concurrent with what I'm doing here.
Okay. And you pled guilty to those charges?
Yes.
Okay. What happened?
In court or?
Just with the charges?
I was living in an Oxford house up there, and my probation officer I had a warrant for here. And so when I asked my friends to come get me, to bring me back to here, they came up in a stolen truck, and they stole a trailer while they were up there, and I didn't know about it because I'd been in rehab. And so they swarmed us at the gas station, and the dude who was in the truck ran, and so they charged us all with the same thing. And so it was either take it to trial or just take the charges. And so I just took the charges to run concurrent with here so that I could move forward with.
Have you stayed in contact with your probation officer?
Yes, I've reported every month since I've been in jail.
Okay. How about before that, while you were on probation?
I was reporting, and then I went to rehab and stuff. So.
Okay. Did your probation officer know that you were going to rehab?
Here, right, this probation officer?
Yes.
I haven't spoken to her yet.
Okay. And before you were arrested, did you have a job or anything like that?
I was working. I was working as a home health care. I was taking care of a lady at home.
Okay. And you said you were arrested approximately 4 months ago, 4.5 months ago?
Yes.
On this violation?
I've been in jail since September 7th.
Okay. And was that on this violation?
Yes.
And do you think that you're going to benefit from going to, you called it Archangels?
Yes.
Okay. What are they going to help you with?
They help you get to and from work. They go to meetings. They drug test. It's a sober community house. So.
Okay. Now, you got in trouble, you got new convictions, right? Okay. Are you going to be able to avoid that in the future?
Yes.
Okay. What do you think's different now?
I was sober when I came to jail. I just got out of rehab. And so going to meetings and getting a sponsor and changing the way that I live and who I hang out with and the people, places, and things, I think it makes a big impact. And I'm just ready for something different in my life.
Okay. So you think that you would be successful on probation?
I do. I think I could complete it.
Is there anything else you'd like the court to know as far as your goals for you being on probation?
I'm really trying to live cleaner and healthier, and I'm trying to be back with my son. And I'm ready for something different, and I know that I can do it. I know I messed up, but I think if I was given the opportunity, I could really do it.
Okay, thank you. I'll pass the witness, Your Honor.
All right. State may cross-examine.
Ms. Blackwelder, you said that you had just completed treatment somewhere, is that correct?
Yes, ma'am.
Where was that?
Jackson, Tennessee.
And what was the program?
Jacoa,
And how long of a program was that?
30 days.
And when did you complete it?
In August, and then I went to an Oxford house.
And where's Oxford House?
It was in Madison, it was in Jackson.
Did your probation officer know you were going to all these places?
Well, I was also on probation in Williamson County, and so they sent me there. And so when I got there, I tried contacting her, but I couldn't get a hold of her.
So are you currently still on probation in Williamson County?
No, ma'am, I flattened that.
You flattened that sentence?
Yes, ma'am.
What was that for?
1129 misdemeanor probation for simple possession. I'd been on that probation for a while.
Okay. And you're saying that you completed this in August, is that right?
Yes, ma'am.
Why do you want to go to treatment again?
I don't want to go to treatment, like the rehab. It's just a sober living house.
Okay.
And I think that it would help me keep me on the right track. And they help you get to and from work, so I can save up to get my license back. And it's close to my family because my family lives in Ashland City, so.
Did you say it was in Charlotte?
Yes, ma'am.
Okay. Where is it in Charlotte?
I'm not sure the exact address, but I think it's over by the Amish store.
Okay.
It's on Old Charlotte, I think, Old Charlotte Road.
So you admit obviously that you just recently got 3 new convictions, is that correct?
Yes, ma'am.
The theft, the simple possession, and drug paraphernalia.
Yes, ma'am.
And what was the drug that you were in possession of?
They said that it was fentanyl, but it wasn't my possession. I didn't have it. It was just in the front seat of the vehicle so the dude that was in the car, the truck, he ran and he ran over the median and ran through all the traffic and everything. I wasn't in the vehicle, but my phone was in the front seat when he took off. And so because my phone was in the front seat, they said that I was in the front seat, and so they charged me with it, but it wasn't mine.
But the fentanyl was found in the front seat where your phone was, right?
It was in the floorboard, I guess.
Okay. And you were charged with another charge in Hickman County, is that correct?
Back in April of last year.
Don't tell me about it, because is it still pending?
Yes, ma'am. They won't come get me. I've written
Okay.
out to them 5 times, and my mom called up there too, and they said that they don't transport anymore.
Okay. But you have a current pending charge in Hickman County, right? For simple possession?
Yes, ma'am.
Okay. And you didn't report that charge to your probation officer, did you?
No, I did not.
And
Because I hadn't been convicted on it, so I didn't know that I was.
She's only admitted the violation as to the new charges. That's the basis for her violation.
And Judge, I'm not asking about the details of her crime, only about whether or not she was charged with it.
Well,
And then obviously about another basis of the other charge, I feel is
so if
appropriate.
I'm understanding, there is a pending charge in Dickson County,
In
Tennessee?
Hickman,
Hickman County.
And that, Your Honor, is the basis, is the basis of her other, the other alleged violation in this case, and that's not what she's admitted.
Well, I think, again, she's admitted her violation. It's just a question of disposition. If it's still pending, what may or may not happen. So I'm going to overrule the objection, but she cannot be asked about the details of the crime.
yes,
But
Judge.
I think the question of whether it is pending or not is relevant.
Yes, Your Honor.
Ms. Blackwelder, have you ever refused to appear for a drug screen?
No, I have, it says I didn't show up for the drug screen, but I never got a phone call, or I would have showed up, because I haven't failed a drug test since I've been on probation.
Okay, but you were using drugs, correct?
Again, I would object to this on the same basis, Your Honor. That's the alleged violation in the initially filed warrant.
Judge, I don't think it is an issue whether or not I can ask questions of this witness in regards to whether or not she admitted to that violation or not. It's still a relevant question.
Even if she's, well, number one, if she's admitted the violation, then she's more or less admitted that she was charged with violating her probation, and she's admitted that. And if she is asking for a disposition, And the question of whether or not she is or is not using drugs or has not used drugs is relevant, so overrule the objection.
Yes, sir.
So you said you never tested positive on a drug screen, but were you using drugs?
I smoke marijuana sometimes, yes, ma'am.
And that's why you went to rehab?
Yes, ma'am.
Okay. I don't have any further questions.
I have no redirect, Your Honor.
So you're saying that there is a sober living house in Charlotte, Tennessee?
Yes, yes, sir. It's
And you're
on,
saying it's somewhere near the Mennonite store, Country View,
I believe so. I believe it's on Old Charlotte Pike.
but you've not ever been there?
No, sir. But I have a bed there.
You have a bed there?
Yes, sir.
And you have any documentation about that? Anything that, in writing that says you actually have what this place is and what kind of reservation you have?
It's called Archangels. I was supposed to meet with the case manager yesterday at the jail, but she never came and got me, so I don't have anything with me.
Step down. Have a seat by your lawyer. Mr. Talbot, do you have anything else?
No, sir.
Defense is rested. Do the state wish to call any witnesses? Officer Bright, if you'll step around here and raise your right hand and be placed under oath.
Officer Bright, you are the supervising officer for Ms. Blackwelder, is that correct?
Correct.
And did you request a original violation of probation on Ms. Blackwelder?
I did.
And can you tell us what the reasons for the original violation were?
The original violation is for a citation that she was given in Hickman County for simple possession casual exchange, and that she failed to report that, as well as she failed to report for her random drug screen on 4/17/2025. Those were the basis for that original violation.
Was Ms. Blackwelder instructed to appear to have a drug screen?
She was.
And she did not appear, is that correct?
She did not.
So she had notice to be there before your
She did.
office?
She even apologized through text message later that she missed her drug screen.
All right. And then on, did she provide you with any notice of this new charge in Hickman County?
No.
And I realize it's still pending. Do you know when it's set for?
I do not. I just asked Hickman if it had been disposed of. They said no.
Was Ms. Blackwelder supposed to be out of the county?
Typically, no, not without discussing it with us.
Okay. What about in the first amended violation of probation?
That is for a new arrest in Madison County, Tennessee, where she was charged with theft, casual exchange, and possession of unlawful drug paraphernalia.
And that's the one that she's admitted to the convictions of, is that correct?
Correct.
Okay. And was she supposed to be in Madison County, Tennessee?
No.
Did you know about these drug rehabs that she said she was at?
The only one I was aware of was Jacoa, and that the letter that I had received from Jacoa said she entered that on August 20th of 2025.
So you knew she was in Jacoa, which, was that the one in Jackson, Tennessee?
I believe that's where Jacoa is.
Okay. But did not have knowledge that she would be in Madison County or Hickman County?
No.
Is there any further information you think the court should know on Ms. Blackwelder?
I am not aware of any Archangel sober living or anything along those lines in Charlotte, so I'm not sure if that is even a thing.
Okay. Thank you. I don't have any further questions.
Mr. Talbot, do you have questions?
Is there a rule against a probationer leaving the county?
There is.
There is? Okay. Is it that they're they may not ever leave the county, or they just have to notify
No,
you of
it's
that?
not that they can't ever leave, but I can, let's see. It is one of the rules of probation. Rule number 5, I will get the permission of my probation officer before leaving my county of residence or the state.
And you testified that she didn't obtain permission to leave the county?
Correct.
Okay. I have no further questions. Thank you, Your Honor.
At the time that Ms. Blackwelder entered her plea back in 2023, one of the conditions was that she was to undergo an alcohol and drug assessment and follow treatment recommendations. To your knowledge, do you show if she's done that?
I believe I had her do one with our office.
All right. Thank you. You may step down. Anything further from the state? Any rebuttal proof, Mr. Talbot?
No, Your Honor.
Then I'll hear you an argument.
The court heard Ms. Blackwelder admit that she did violate the law and she got convictions for that. She took ownership of that. She was given a probation sentence in that case. That presents an opportunity for her, in this case, should she be reinstated to probation, to take advantage of that opportunity and go into sober living that she described. So she anticipates that she would be able to succeed on probation with the support of that sober living that she anticipates entering. And I would also note for the court that she had some significant time on probation where she did well. From the date that she entered her plea originally and was sentenced to probation back in the 13th of January 2023, all the way through she testified that she was arrested September 7. But the court could go through I suppose, the filing of the first violation warrant, which would have been back on 16 June 2025, when the state alleged that there were problems relating to her performance on probation. So that's a period of over 2 years, I think, Your Honor, January 2023 to June 2025. But I would ask that the court, if the court does revoke her to serve her sentence, that she be given credit for that period in the court's discretion. The court has the authority to do that. Also, she's clearly shown that she put a lot of thought into trying to get her life together and succeed on probation by making this plan to enter Archangel's recovery house there. And she also has significant jail time that she served already, approximately 4.5 months by her testimony. That is a significant penalty, which the court could stand on in ruling that she's sentenced to the time she's already served. That would be a proportionate sentence for her in this case, followed by her reinstatement to probation. We ask that the court consider that, and then reinstate her to probation with any appropriate conditions. Thank you, Your Honor.
Your Honor, it appears that Ms. Blackwelder has chosen to continue to commit crimes while she's already on supervised probation. This was her opportunity to be successful, to take advantage of what the probation has to offer. She pled guilty to aggravated burglary and possession of marijuana as her original sentence back in 2023. She has now since been convicted of 3 new misdemeanor charges, including a simple possession, drug paraphernalia, and theft. She, according to the probation officer, she has another pending charge, which obviously has not been resolved in Hickman County on simple possession. She's failed to report to drug screens as requested by her probation officer and didn't report the arrest, as well as being out of county. I don't think Ms. Blackwelder is going to obey the rules of probation. It's pretty clear based on each of the rules that she has violated that it doesn't appear she is ready to be successful on probation. I would ask that she be revoked to serve.
Of course, always willing to try to give someone an opportunity to try to get help if they have a dependency problem. Not sure that Ms. Blackwelder has really gotten a grip on what her problems are. Clearly, she has violated the terms and conditions of her probation not on one occasion, but on multiple occasions. So for that reason, I find that she is guilty of violating her probation as she admitted, and that an appropriate sentence is to require her to serve 1 year, and following the service of 1 year with credit for time served, she will be returned to active probation, but her probation will be extended for 1 year as well. So she's going to have an additional 1 year to serve on probation, and she'll have 1 year to serve with credit for time served. And that will be the judgment of the court.
Thank you, Your Honor.
Let's go to the Dickson County Jail. And I believe this would be Miss Connie Presley. It is on page 18. Ms. Presley, can you hear me?
Yes, sir.
I think you're represented by Mr. Spratt.
Yes, sir.
Is there any way I could have Miss Presley? I didn't get the docket. I think I've been taken off the list. If I could have her brought down for second call.
Ms. Presley, your lawyer wants you to have you brought down, so I'll have you brought down as soon as we can get you here. So,
Thank you, Your Honor. Thank you, Mr. Lake.
saying he's been taken off the list. I'm not sure what list it is, but
The email list.
Presley, we'll see you in a few minutes, okay? Thank you. All right, we have another inmate here. All right. Bring one on out. All right, if we got a female inmate, let's bring her out. Rebecca Miles, that's on page 16. All right, at the jail, what is your name, please?
Yes, Green.
Is that your client as well, Mr.
It
Flanagan?
is, Judge, and we are not ready to set it for trial yet. That's General Stovey's case, so we need another status date.
Let's go September 23rd. All right, next status will be September the 23rd. Let your lawyer continue to try to work on your case.
I'll be up to see you, Chad.
All right. Anything about a bond?
Well, that's what I'm gonna come talk to you about.
Okay.
Okay.
Thank you.
And we're waiting on Rebecca Miles.
Judge, I'm going to have her sign the plea petition,
Okay.
and this will be a no contest plea with a sentencing hearing. So,
All right, Ms. Miles, raise your right hand. Let's place you under oath.
Yes, ma'am.
State your full name for the record.
Rebecca Ann Miles.
Ms. Miles, you're here on a multi-count indictment in docket number 2025 CR 59, and then you're also here in 2025 CR 294 on a charge of domestic assault. It's been indicated that you want to enter a plea of no contest to 4 of the counts in the first indictment, and that the second one will be dismissed as a part of that along with the other counts. Have you seen or been shown a copy of those charges, talked them over with Mr. Flanagan, you, and he discussed the range of punishments you're facing as well as possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea of no, would you mute the jail for me, please? Well, it's indicated you want to enter a plea of no contest or nolo contendere. All that means is you're not going to admit you did anything wrong, but you're not going to contest the state's evidence. And as a result of that, the state will tell me what their evidence would be at trial, and I will use that evidence to find you guilty according to this agreement. You understand that?
Yes, Your Honor.
Understand that you have a right, however, to plead not guilty and to all charges and to have a speedy and public trial by jury.
Yes, Your Honor.
You understand that if you went to trial, you would have the right to have a lawyer and have one appointed if you could not afford your own.
Yes, Your Honor.
Do you understand that trial you would be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that at trial, you and Mr. Flanagan could confront and cross-examine every witness the state calls to testify against you, and you can bring in your own witnesses by using a subpoena?
Yes, Your Honor.
At trial, you would be presumed to be innocent. You would not have to testify or prove anything. Do you understand that no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by entering a plea of no contest to these 4 counts, you're waiving your right to contest your guilt or innocence on those charges?
Yes, Your Honor.
You understand that that's going to result in 4 felony convictions, or 4 convictions, and I think it would be all, one's a misdemeanor, and that at that point in time, we will then be setting a sentencing hearing for the court for me to determine what your sentence would be.
Yes,
You
Your Honor.
understand that?
Yes.
Do you understand that while you're waiving your right to contest your guilt or innocence to those 4 counts, you're preserving your right to appeal whatever I did in a sentencing hearing?
Yes,
Do you
sir.
understand that? Do you understand everything I've explained to you?
Yes, Your Honor.
Do you wish to plead no contest according to this agreement and waive your right to a hearing?
Yes, sir, I do.
Are you satisfied with your attorney's? Well, first of all, let me ask this. Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will?
No, sir.
Do you understand I cannot accept your plea unless I'm satisfied that there are facts to support a finding of guilt in your case?
Yes.
And I need you to listen as the state tells me what their evidence would be if this case went to trial. If you'll step aside for just a moment, let the state come up to the podium.
Your Honor, if this were to proceed forward to trial, the state would intend to show that on or around January the 22nd of 2025, Ms. Sanders was operating a school bus for Nashville Christian. On the school bus was a 6-year-old with the initials KO. They were going down Highway 70 and were going to turn left onto Highway 96 in the left turn lane. The state would intend to show a witness coming from Highway 70 going towards Dickson before approaching the intersection, observed a red car being operated in a dangerous manner. Then when going around the curve, this red car ultimately struck the school bus, causing it to ignite and catch fire. The driver, Ms. Sanders, and the 6-year-old had to get off the bus and run up the hill to the nearby church for safety reasons. At that point, whenever officers arrived and on body camera, the bus is fully engulfed in flames. This did place Ms. Sanders and the 6-year-old at risk of serious injury. On scene, Ms. Miles had a gash on her head, but ultimately when Sergeant Deloach went to speak with her, he noticed a strong smell of alcohol from her. A blood vial was ultimately collected, showing her to have a .113 BAC. On top of mixing that with her oxymorphone, 9 nanograms of that as well mixed with it, which TBI would say would have a synergistic effect, ultimately enhancing the effects of each other, not simply 1 + 1. Inside of her purse, Ms. Miles did have a prescription for the oxymorphone, as well as a handgun. Ms. Miles is a convicted felon, and she has ultimately previously been convicted for aggravated assault, which would make this a Class B felony. This is notated on the plea petition. For your honor, ultimately, with the sentencing hearing, we'll be looking at 8 to 12 years, which will be the manner of service, and ultimately the length will be decided by your honor. As required under TCA 40-35-501, both the child endangerment as well as the felon in possession of the firearm are 100% offenses. That is notated on the plea petition. Those are the facts that the state would intend to show for purposes of the DUI with the .113 and the oxymorphone, the reckless endangerment of the bus driver, the child endangerment of KO, and the possession of a weapon by a convicted felon. Thank you.
All right, Ms. Miles, I'm not asking you to agree with those facts, but do you understand that's what the state's evidence would be if you went to trial?
Yes, Your Honor.
You still wish to plead no contest?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
You feel that Mr. Flanagan's done a good job of representing you competently?
Yes, Your Honor.
Mr. Flanagan, you know of any reason she should not enter these pleas? No. And we need to go ahead then and set a sentencing hearing. I do find that she is guilty in count 2 of driving under the influence of an intoxicant. Count 4, I found her guilty of reckless endangerment with a deadly weapon. Count 6, I found her guilty of child endangerment of a child less than 8 years of age. And count 8, I found her guilty of being a felon in possession of a firearm. We will then set a sentencing hearing. I assume that September would probably be as early as we can get that done. July. My criminal docket is on the 14th of July. VOP day would be 28th. We can set it at 1 o'clock on the 28th of July.
Please, because I'll be in trial on homicide.
Is the 28th okay? All right. Mr. Flanagan, is that all right for you?
It is, sir.
We'll set it at 1. Let's do it at 1:30 just to be safe, but 1:30. We need a pre-sentence report, yes. July this 28th. All right. All right, at the jail is, are you Ronnie McCoy? You're muted. You'll have to unmute that device.
Yes, Your Honor, I have, Brian McCoy.
All right, Mr. McCoy, your lawyer has asked that you be brought down, so we're going to bring you down so that you can hopefully dispose of this case, all right?
Okay, thank you.
Thank you.
Thank you, Judge.
Next up, I've got Tanner Bishop.
All right, you need to talk to Mr. Bishop. All right, we'll put it on the second call. You have another one, Sergeant?
Bring out Jason.
All right, bring him up, please. Good morning.
I represent Mr. Bradford.
Judge, on Mr. Bradford's, we're still in discussion about his case, and we're just gonna ask to second call it if possible.
All right, we'll put it on the second call. Bring us out another one. Ryan Carmona. Mr. Atchison, are you ready on Brian Carmona?
Judge, I'm going to pass forward Mr. Carmona's plea petition as it relates to his VOP.
All right. Shows that he is going to admit his violation of probation, waive the hearing, and be sentenced to serve his sentence with credit for time served.
That's correct, Judge.
All right. Mr. Carmona, raise your right hand. Let's place you under oath. Thank you. State your full name for the record.
Brian Jesus Carmona.
Mr. Carmona, you're here today on a violation of probation. Do you understand you have a right to plead not guilty and to have a hearing where the state would be required to prove to the legal standard that you had violated your probation?
Yeah.
You understand you'd have the right to have a lawyer and have one appointed if you cannot afford your own?
Yes.
Do you understand that if you went to that hearing and I found you guilty, you could appeal what I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand that by pleading guilty, you're going to be waiving your right to the hearing and to the appeal. All I'm going to do is revoke you to serve your sentence with credit for all your time.
Yes, sir.
You understand everything I've explained to you?
Yeah.
Do you want to plead guilty according to that understanding?
Yes.
And upon your plea of guilty, I order that you be revoked to serve your sentence with credit for all your time, and your lawyer has set forth all of the days that you're entitled to on this document, okay?
Yes, sir.
All right, thank you, Mr.
Thank you,
Atchison.
Judge. I'll get it to you as soon as they get it hooked up.
We heard from Crystal Wilkerson before we bring out Derek Dillard.
I believe they're back there speaking with him. I've got Kadarius Godwin.
Okay. Darius Godwin, page 6. All right, now I'm ready if you are. Just, if the public defender will cooperate by letting him have that table for us to have this hearing on Mr. Cardarius Godwin.
What?
All right. Yes.
Mr. Bishop is going to get a trial date on that helps the deputies if they can take him back, so.
All right, and we don't need Mr. Tyner Bishop brought out?
No,
We'll
we
just-
don't. I've told him what we're doing. That's General Bryson's.
all right. Well, let's just go ahead, before we start this hearing, let's go ahead and set a trial date. You're wanting a trial date on the sex offender registry violation form, correct?
Yes.
State have a date in mind that you want to try Mr. Tyner Bishop on that charge? Probably looking at January.
Judge, I don't have your trial dates marked, so I think it's a one-day trial.
What about, is it one-day trial?
Yes,
Could be
Judge.
half a day. I think it's going to be non-jury.
January 15th?
That's fine, Judge.
January 15th. VOP will be moved to January 27th.
Thank you, Judge.
All right, we're back on Cordarius Godwin, defendant's motion to reinstate bond.
I said, we have an order for expungement for the case that was tried in January and February. And I'll call Mr. Godwin briefly, Your Honor, but just to go over some of the things in the motion. Briefly, Your Honor, just to recall the timeline of events as to his bond revocation, the state filed a motion in 2020 CR 192. Court had a hearing on February 21st of 2024, and court granted that motion and sua sponte revoked Mr. Godwin's bonds in the remaining matters, one of which was docket number 2021 CR 256, which we had a jury trial in January and February, and Mr. Godwin was found not guilty. The basis that the state laid out for that bond revocation was a charge in Lawrence County that was dismissed. An officer passed away down there. That was dismissed. And a certified copy of, I believe, the affidavit of complaint in that case was entered over objection. And he's since been found guilty. Would note for the court that docket number 2020 CR 192 and 2020 CR 351 were not bond-on-bond crimes of allegations. He was arrested for one, bonded out. Another one that had occurred previously, he was arrested shortly thereafter. So he's been held, and if I'm not mistaken, he's done at least 2.5 years, maybe 3 years on these remaining charges. And his bond's been revoked without any cross-examination of any of that. So what we're asking today is that he be his bond be reinstated on the remaining matters, or a reasonable bond be set. And I can go ahead with that being said and call Mr. Godwin as to the
All right,
factors.
Mr. Godwin, if you'll come around, please.
Could you state your name for the record, please?
Darius Godwin,
Okay. And Mr. Godwin, where are you currently being housed?
Dickson County Jail,
Okay. And how long have you been there?
2.5 years.
Okay. Did you do some time before that on
Yeah.
this case?
Yes.
Okay. And now, was some of that time at the outset of the case where there was a capias issued for a failure to appear? Okay. And did we have a motion to reinstate your bond based on that being a communication error with Ms. Fordyce?
Yes, sir.
Okay. And was your bond reinstated based on that hearing?
Yes, sir.
Okay. Have you ever had any other failures to appear?
No, sir.
Okay. And were the charges against you in Lawrenceburg, were those dismissed?
Yes, sir.
Okay. And if you were released, where would you be living?
Lawrenceburg, Tennessee.
Okay. And is that an apartment?
Mm-hmm.
Okay. And did you live in Lawrenceburg while this case has been pending when you were on release?
Mm-hmm. Yes.
Did you fail to appear at any time for
No,
that?
sir. No, sir.
For any of these hearings?
No.
Okay. Would you be willing to wear an ankle monitor if you were released, if the court required that?
Yes, sir.
Okay. And any other conditions, would you comply with those?
Yes, sir.
Okay. And do you have other family in the Lawrenceburg area?
No, sir.
Okay. Do you have other family in the Middle Tennessee area?
Mm-hmm.
Okay. And who are some of those?
And the Tosca Godwin,
Okay. And where does she live?
Murfreesboro.
Did you stay in contact with her often?
Mm-hmm.
Is she in the courtroom today?
Yes, sir.
Okay. And how much bond could you afford if you were released?
I don't know.
Okay. Did you work while you were out?
Yes, sir.
Okay. What type of work did you do?
Cabinet installation.
Cabinet installation?
Mm-hmm.
Did you work at some restaurants?
Mm-hmm. I worked at Chili's.
At Chili's? And did you work at Applebee's?
Mm-hmm.
And you've stayed in contact with me anytime you've been out?
Yes, sir.
Okay. Would you continue to stay in contact with me?
Yes, sir.
Okay. Those are my questions, Your Honor.
General Bryson.
Mr. Godwin, you have a pretty lengthy criminal history, is that right?
Yeah, mostly from a juvenile.
Okay. When did you get your first criminal offense?
2007.
And that would be when you got your robbery, ag burglary, a second robbery, an aggravated kidnapping, a theft of property, and an especially aggravated burglary, an aggravated robbery, an aggravated kidnapping, and a carjacking. You got all of those in 2007, is that right?
Yeah, it says a juvenile.
And you were transferred to adult court?
Yes.
Have you ever failed to appear for a court date other than the one where there was a mix-up with Ms. Fordyce?
No.
Are you sure?
I can remember.
So you don't remember failing to appear in 2017 or driving on revoked here in Dickson County?
No, ma'am.
You don't remember pleading guilty to that, to a contempt of court in 2018?
No, ma'am.
So do you think, if your criminal history shows that, is it wrong or you just don't remember? No, different question.
It's a different question, overruled.
So are you saying if your criminal history shows that it's wrong or you don't remember?
I just don't remember that one.
Do you think your behavior in the jail has been good?
Yes, I'm in the honor pod.
Have you had any jail write-ups during your time?
Yes.
What have you been written up for in the jail?
Destruction of county property.
What did that involve?
I broke a visitation handpiece
Is that your only write-up in the jail?
that I was charged and found guilty of, yes.
Have you been written up for other things that you weren't found guilty of?
Yes.
What else were you written up for?
For letting somebody use my phone PIN number, but it was a mix-up.
Have you, during your time in the jail, have you ever had your phone privileges suspended?
No.
Where did you say you intend to work if you get out?
Well, I'm starting to go back to CDL school.
CDL school?
Yes, ma'am.
And where will that be?
Columbia.
Is that something you have to apply for?
I already started the application process.
Okay. So have you turned in that application?
Yes.
And when will you hear back on if you've been accepted?
I don't know yet. It's still in progress.
The place that you're going to live, will that be with other people?
Yes.
Who else will be living in that house?
Emily McCall,
Okay. Who is Emily McCall?
my girlfriend.
Does she have kids?
No.
Will anyone else be in the house?
No.
During your time in jail, have you maintained communication with Miss McCall?
Yes, ma'am.
Okay. Have her calling privileges ever been suspended to you?
No.
Are you sure?
Yes.
So you don't remember when her call privileges, her video call privileges were suspended?
Yeah, her visitation was.
Okay, why was her visitation suspended?
I don't remember.
Could it have been because of sex acts on those phone visitation?
Maybe yes.
A sex act? Is
Yes,
this a
Judge.
video call from the jail? Is that
Yes,
correct?
Judge. So you don't remember or you don't want to say?
No, I said it could have been
It could have
sexual
been.
conversations.
Nothing further, Judge.
Mr. Spratt, do you have any redirect?
About 5 years.
5 years. And you've done how long in jail? You said 2.5 years this time. Do you know how much you did up front?
Up front about 11 months, almost a year.
So almost 3.5 years.
Yes,
on these charges.
yes.
And you were not, okay, those are my questions.
Anything further from the state? Thank you, sir. You may step down and have a seat by your lawyer. Mr. Spratt, you may call your next witness. Excuse me, the defendant has rested their proof. State, have any witnesses you wish to call? I'll hear you in argument.
Godwin has done some 3.5 years. There are 3 cases remaining, one of which is a vandalism, one of which is an E felony, and then there is another B felony pending. 2 of those were, as I said, were indicted, not at the exact same time, but they were not committed or alleged to have been committed while he was out on bond. He's done, as I said, 3.5 years. His bond's been revoked on these charges. First basis was dismissed. In Lawrenceburg, the first case tried was not guilty by jury verdict. And he's yet to cross-examine a witness about any of the basis for any of this revocation. So he's not, I would reassert that I don't think he's had a meaningful Bergens hearing yet as to why he can't be on bond. As to the failure to appear, that was an error that we sorted out upon my appointment of the case. So he's testified that he would be willing to comply with an ankle monitor and show up to court. And he has stayed in contact with me throughout the pendency of these cases. So we're just asking that the court either reinstate the reasonable bond or understanding the serious nature of the charges. He does carry the presumption of innocence. And so we ask that based on all of the factors, that the court set bond at $50,000 aggregate to assure Mr. Godwin's appearance at the future proceedings with the condition of an ankle monitor and any such other conditions.
General Bryson.
Judge, this bond was appropriately revoked. Originally, this court has already entertained and heard one motion to reinstate this bond, which it denied in December of 2024 and entered that order. The defendant on this case has a criminal history that ranges him to a career offender. On that B felony, that means he faces 30 years if convicted. The court has had an opportunity through its interaction with this case, through the file that's in front of it, to be both aware of Mr. Godwin's criminal history and other conduct. Judge, if the defendant was granted bond, which I think the bond revocation is appropriate and should stay, if the defendant is granted bond, not only should he have an ankle monitor, he should not be allowed around any business that serves alcohol. Judge, the court is well aware of the nature of the defendant's cases and that he is a danger to the public. With his prior history, with the attaining of new charges, regardless of their disposition, the bond revocation is appropriate. The state would ask for an extremely high bond if he was granted a bond, as well as conditions tailored to keep the public safe.
The state sought the revocation of the defendant's bond pursuant to 4011-141. Subsection B of that statute says the following: if after the defendant is released upon personal recognizance, an unsecured personal appearance bond, or any other bond approved by the court, the defendant violates a condition of release, is charged with an offense committed during the defendant's release, or engages in conduct which results in the obstruction of the orderly and expeditious progress of the trial or other proceeding, then the court may revoke and terminate the defendant's bond in order that the defendant be held without bail pending trial or without release during the trial. And is note that the court notes that it is not required that the defendant be convicted of those charges that occurred during his release from jail, only that he be charged. Clearly, the state's motion to revoke his bond initially was based upon not just the charge that he went to trial on. Instead, it was based upon the fact that there were a number of charges, including the ones that later got dismissed in Lewis County. And this court is of the opinion that the state's motion was well taken at the time. Revoke that bond based on that fact. Now the defendant comes back in asking again to be reinstated to bond simply because he stood trial and was acquitted on the one charge. But he is presently facing a charge of Class B felony rape in docket number 192, 2020 CR 351, and then vandalism, which is a Class E felony in the other case, which is 2021 CR 59. The state has filed an amended notice of impeachment and range of punishment, and I think it's instructive to review that. He was found guilty in Circuit Court of Madison County, received a 6-year sentence for a Class C felony of robbery. He was found guilty, and that was in 2007. In 2007, he was also found guilty of aggravated burglary, a Class C felony, and sentenced to 6 years. He was found guilty in that same time period of robbery, Class C felony, and received a 6-year sentence as well. 2007, again, he was found guilty of aggravated kidnapping, a B felony, received a sentence of 8 years, 2009 in Madison County. He was found guilty in Madison County in 2007 of theft of property, $1,000 to $10,000, a D felony, received a sentence of 4 years. He was found guilty in Madison County in 2007 of especially aggravated burglary, a B felony, received a sentence of 10 years. He was found guilty in Madison County of aggravated robbery, a B felony, sentenced to 10 years, and that's also in 2007. He was also found guilty in Circuit Court of Madison County of aggravated kidnapping, a B felony, and received a sentence of 10 years. He was found guilty in Madison County of carjacking, a B felony, received a sentence of 10 years. All of those offenses are felonies that will bump the range of punishment up to a career offender, and so as correctly was pointed out, the defendant is facing a substantial sentence if he is found guilty of either one of these charges, actually, but certainly of the Class B felony. And in this case, he is charged with sexual battery and vandalism. So in docket number 192, which is the case that is pending, he is charged with sexual battery without consent, which is a Class E felony, is also a Class A misdemeanor. So he has another charge of rape, another charge of sexual battery without consent, and then a couple of misdemeanors. This court is of the opinion that the court acted correctly in revoking his bond to begin with, and I find that simply because of the charges and the nature of the charges and the fact that there are a substantial sentence awaiting Mr. Godwin if he is convicted, that the revocation of his bond should remain in place, and I therefore deny your motion to reinstate. We're going to take a 15-minute recess.
All rise.
And what would that be? Charles McDonald. Okay, 923. Mm-hmm. Yes. 923 on. Kevin James Moran. When do you want to set it? I mean, it's VOP, do you want to set it in June? All right, June 29th. All right. What's next? Okay, what do you have, Mr. Flanagan?
Judge, on Dalton Hooper, if we could have one more status date, he's here before we set it for trial.
On page 9, do you want to set it for September the 23rd?
Yes, please.
September 23rd will be the final status day.
Thank you, Judge.
Okay, we ready for inmates? Bring out the first one. We bringing out the inmates? Okay.
Pages 9 through 11. What we would like to do is go ahead and have Mr. Jackson admit the violation, but have a hearing on disposition.
All right. State your full name for the record.
I can't tell Rashad Jackson.
Mr. Jackson, you're here today on violation of probation on a number of different indictments, but you have, you understand that you have the right to plead not guilty to that and have a hearing in this court where the state would be required to prove to the legal standard that you had actually violated your probation. You understand that if you had that hearing, you would have the right to have a lawyer and have one appointed, as I've done with the public defender.
Yes, sir.
You understand if we had the hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with the appeal. You understand that by pleading guilty to the violation, you are actually waiving your right to the hearing as to whether or not you did or did not violate your probation. But you are preserving your right to appeal whatever I do at a sentencing hearing on that. Do you understand that? You understand everything I've explained to you? Do you want to admit your violation and go to a disposition hearing?
Sir.
All right, then I find you're in violation of your probation and we'll have a hearing. So Howard, you ready to put on your proof?
Yes, sir, if we could call Mr. Jackson.
Mr. Jackson, if you'll step around here, please.
So, Mr. Jackson, this violation is based off of some new charges that occurred here in Dickson County, is that correct?
Yes, sir.
And you've resolved those charges?
Yes, sir.
When were those resolved?
I forgot the day,
Well, we don't need the exact date. Would you estimate a couple weeks, a month,
a month ago.
month? And what happened with those charges?
I had 3 ran concurrent with my 8.
Okay, so you pled guilty to those charges?
Yes, sir, with lesser charges.
Sure, but you didn't contest them, and you're
No,
not
sir.
contesting this violation,
No, sir.
okay? And prior to that, you were in the drug court here in Dickson County, right?
Yes, sir.
How long were you in that program?
2 years.
And what was the outcome of that program for you?
Graduated.
How were you doing while you were being supervised by them? Tell me about life.
It was good. Right.
What about after you graduated the program? What happened? How did you get off track?
Less structure.
Yeah? You fall in with the wrong crowd?
Yes, sir.
All right. What do you think would have prevented that?
Should have went over to the halfway house program of drug court.
Was that a voluntary decision on your part not to do that?
Yes, sir.
Okay. Regretting that decision now?
Yes, sir.
All right. What is it that you want to be the outcome of this proceeding here?
Looking for community corrections, add a year on my 8, and move it to community corrections.
Okay, so you're just seeking more structure in that regard?
Yes, sir.
All right. I'll pass the witness at this time, Your Honor.
Mr. Jackson, you are on probation for theft, aggravated burglary, false reports, burglary ×3, and failure to appear. Is that correct?
Yes, ma'am.
And you've had a prior violation of probation hearing.
I don't recall.
You don't remember being violated before, and that's what sent you to drug court?
Ma'am, I went to Clarksville jail, and then somehow Dickson got me back, but I didn't. I was on probation at Clarksville, and my PO said that she wouldn't violate me because I got arrested right in front of her.
So you don't recall a violation hearing in which you got sent to drug court?
No, ma'am.
All right. And then, when did you graduate from drug court?
December 28, 2025.
And you admitted that by February, you had absconded from your probation. Is that
Yes, ma'am.
correct?
Yes, ma'am.
You had quit your job or was terminated for basically not showing up at Nashville Wire. Is that correct?
Yes, ma'am. Got another job.
And you, in February, before you absconded, you tested positive for cocaine.
Yes, ma'am.
And this is all within less than 2 months of you completing drug court.
Yes, ma'am.
You also, in April, got charged with domestic assault ×2, aggravated assault, interference with an emergency call, and aggravated burglary of a habitation. Is that correct?
Yes, ma'am.
And then you've pled guilty, you said, to 3 of those counts,
Yes, ma'am.
and were given a misdemeanor sentences.
Yes, ma'am. For lesser charges.
Okay. And the offense of, let's see. Who was the victim of the domestic assault?
Tierra Bethke.
She's here today too, it looks like, I think. Do you know that?
Oh, ma'am.
Okay. Was Tierra Bethke in drug court as well?
Yes, ma'am.
And she had graduated around the same time?
No.
Thank you. I don't have any further questions.
Redirect.
Okay, so I think we're getting confused about some things, Mr. Jackson. So you were on probation in Dickson County, right?
I was on probation in Clarksville, Tennessee.
There's an old Dickson County case that you had a probated sentence for. I understand you were reporting in Clarksville, but you have some old Dickson County cases you were on probation for, correct?
Yes, sir.
All right, and then you got arrested in Clarksville, you said,
Yes, sir.
and you were of the understanding that your probation in Dickson County wouldn't be violated for that.
Yes, sir. I got arrested right in front of my PO, and she told me that I'm not violating you. And then I went and did the 3-1, and then I served a year, and then Dickson came and got me.
Yeah, because there was a violation pending for you.
Okay, yes,
You
sir.
may not have understood that,
Yes,
but,
sir.
all right. And then another thing, so you said that you graduated from court on, a recovery court on December the 28th.
Yes, sir.
But there is an order in your file from February the 9th that was reinstating you to probation. What happened between December 28th and February 9th? Were you still reporting to drug court? Or did you just know you had a court date in the future?
It was the previous Monday or something that I had to go report to Mr. Fry for my intake, and then I started seeing Miss Bright.
Okay, so you were reporting to probation during that time, even though the order reinstating you to probation wasn't entered until the 9th of February?
Yes, sir. I don't know when the intake was, so it was in between the time of seeing Miss Bright for the first time, and then that's whenever I was, I guess, initially reinstated.
And did you let Ms. Bright know in any way, or were you not able to make a phone call once you had the incident that got you arrested?
I never knew about the charges until they came and got me.
Okay,
Till
so
I
you didn't
were-
have the opportunity to let her?
Yes, yes, sir. I never knew anything about any of the charges.
All right. Nothing further, Your Honor.
Anything further? Thank you, sir. You may step down. Howard, you may call your next witness. Do you have any proof you wish to offer? Officer Bright? Different hearings, so raise your right hand. Let's place you under oath again.
I do.
You are Officer Christina Bright,
Yes,
and were you supervising Akey Jackson?
yes.
Now, when did Mr. Jackson graduate from drug court?
It was the end of December.
And was he supposed to report during the time period of January?
I had him come in for intake in January.
Okay, so he reported in January,
Correct.
but he was not reinstated to probation until February?
Correct.
At some point in time, Mr. Jackson stopped reporting well, let me ask you this. February 9th, when he was officially reinstated to probation, is that the day he tested positive for cocaine?
Correct.
Okay. What did you do at that point as his probation officer?
We had several talks, and he did state that he wanted to go to a halfway house because it would be more stable. I talked to him about possibly going back to the drug courthouse, things like that. I don't know that he ever did it, because shortly after he took off.
Okay. Do you recall so February 9th he reported, is that the last date he reported to probation?
I believe so.
How often was he supposed to report to probation after graduation?
He was supposed to be reporting monthly.
And it shows on this, let's see. He failed to report to probation on 2/20 and 2/24/26 on the affidavit, is that correct?
Yes.
Okay. And he obviously hadn't noticed he was supposed to report.
He knew he was supposed to report, yes.
Was he at some point in time found with another drug court graduate?
Him and Tierra Bethke both admitted that they had started a relationship while they were still in drug court.
And is that something that they're allowed to do?
No.
You list in the instructions as well that he was terminated from Nashville Wire.
Correct.
Do you know how long he had been working there?
All throughout drug court, I believe.
Okay. And at some point, he was terminated, looks like, for abandonment. He didn't show up.
Correct.
Do you know where he was during this time he's absconded, or did you find out otherwise?
No.
At some point in time, he was also charged with new offenses.
Correct.
Do you know anything about those new offenses?
There was two. One of them was he broke into the drug courthouse. And then the other one was domestics and stuff with Miss Bethke, I believe.
And that's the person who had graduated from drug court and they were in a relationship
Correct.
with? Okay. Has Mr. Jackson been violated on probation before?
Yes. That's what put him in drug court.
So this is his second violation on his cases involving theft, aggravated burglary, false reports, burglary times 3, and FTA.
Correct.
Do you have any recommendation to this court in regards to how Mr. Jackson will do on supervision?
I don't think he'll do very well at all.
You have anything else further that the court needs to know about Mr. Jackson?
Other than he didn't do very well from right after graduating drug court, I don't recall any significant mess ups during drug court. He admitted that he was in a relationship that he shouldn't have been in, but other than that, I don't recall or remember any significant ones during drug court, but immediately after, he just went downhill.
Okay. Thank you, Officer Wright.
Mr. Howard?
Officer Bright, could you detail for the court just how involved you are with participants in drug court while they're in the program?
I come to court weekly or when court's held. I talk to the participants and stuff if the judge isn't in the courtroom at that time, here and there.
So you're fairly familiar, it would be fair to say, with most of the participants?
Correct.
Okay, and when somebody steps out of line, you're aware?
Correct.
Okay, and Mr. Jackson was in for 2 years, right? Thereabouts?
I would say possibly. I don't know the exact dates.
Okay, and you just testified that during that 2-year period being supervised by drug court, you can't recall an occasion he stepped out of line?
Nothing sticks out to me, but again, we have participants coming and going. I would have to look back at the records, the drug court records.
But then almost immediately, as soon as he didn't have that structure, he just goes off the rails.
Right after he graduated, pretty much.
Okay. So you'd agree that structure keeps Mr. Jackson in line?
Sure, if you're going by just drug court and then him getting out, but he chose to leave that environment.
And
He could have stayed.
you'd agree that's a bad decision?
Correct.
And so do you think the structure of community corrections would be a better decision for Mr. Jackson?
No.
Why is that?
Probation and community corrections can be as structured as possible, but if he's not in an environment that holds him accountable like drug court, then I don't think it's going to make a difference.
Nothing further.
Step down. Do you have any other witnesses? Mr. Howard, do you have any other proof? I'll hear you in argument.
Mr. Jackson is no stranger to the court system. He has gone through several periods over the past, pushing a decade now, 2019, what is that? That's 7 years thereabouts. He goes through periods where he does well, he walks the straight and narrow, and then he gets in with the wrong people. He falls into making the same bad decisions. He relapses. We see this all the time. Mr. Jackson was the first to admit that he made some bad decisions. You heard from the probation officer that when he was involved in drug court and had the structure of drug court, he made better decisions. And what he's asking the court to do is just give him another chance, put him in community corrections, extend his sentence if the court sees fit, but give him some structure and give him an opportunity to go to a halfway house, to get the support that he needs to continue to succeed. He has a ton of credit, Your Honor. He's been doing this a while, and he's just had a slip up. He's asking the court to give him another chance to make it right.
Mr. Jackson has had many opportunities to make things right, Your Honor. He clearly entered a plea in regards to multiple different felony counts, was given an opportunity to be on probation. He violated that probation and was given an opportunity to go to drug court. He went through drug court, which, as this court is well aware, is usually, we consider, the last chance. It's their last chance to get help that they need. Mr. Jackson did complete drug court, but immediately, Judge, he immediately went off the rails, just as soon as he graduated. He absconded, he got new convictions, he broke into the drug courthouse, he tested positive for cocaine, he was terminated from his employment. He just did everything he wasn't supposed to, Judge. He was given an opportunity. Officer Bright testified when he came in on February 9th and reported and tested positive for cocaine, he was given an opportunity. You can go back to the drug courthouse. He chose not to, and now when he's facing his sentence to serve is when he wants structure. I ask that you revoke him to serve.
Well, the question arises is, there's no doubt that this defendant, Mr. Jackson, apparently did better when he had someone looking over his shoulder, and as was stated, that the structure kept him in line. Question becomes, at what point is society required to provide structure for individuals who willingly prevent or commit new offenses? Mr. Jackson was found guilty of, as the state has pointed out, of theft, aggravated burglary, 3 counts of regular burglary, making a false report, and failure to appear. All of those were combined into an 8-year sentence. And he was placed on probation, given that chance. He violated that probation and appeared in front of Judge Larry Wallace, and Judge Larry Wallace approved him going into the drug court program. And as a condition of that, he was to complete the rehab and the drug court program and be returned to probation. So in February, he was, February 25, I guess it was, he was returned to probation. I'm sorry, it's 26. So February of this year, he was reinstated back on probation. And as has been cited by the state, he immediately violated the terms of his probation by not only not reporting, not only testing positive for drugs, but then going out and committing new offenses. So there's no reason this court can find that to believe that if the court returned him to any sort of probation, that he wouldn't go back out and commit new offenses. At this point, as I have to agree with the state, that the drug court program has always been, in this court's opinion, the final last chance for someone to avoid having to serve their sentence. Mr. Jackson had that opportunity. All he had to do is stay out of trouble. And I don't think that he's entitled to a 3rd or 4th chance. So for that reason, I revoke him to serve his sentence. He'll get credit for all the time that he has served. So. Bring out the next inmate. Mr. Sanders, we had Jeremy Jaco that you were representing.
I received a text message yesterday from an acquaintance of my client's that indicated that Mr. Jaco had passed away at 2 a.m. yesterday morning. I don't have any official, that startled me when that door opened. But I don't have any official verification of that. I don't have a death report or, anything like that. But the word that I received was that Mr. Jaco had passed away. I do know that he had been battling cancer, very serious matter, and I did have a confirmation that he was receiving hospice care. So all indications would be that that's accurate information, but I'll supply official word.
Just give us some sort of confirmation of that, and that'll be sufficient. Your reaction reminds me of the story that I don't know if it's apocryphal or true, but someone was on trial for murder, and the defense lawyer, the body had never been found. The defense lawyer was arguing that the state hadn't proven that the defendant was actually deceased. And he turns and says, for that matter, he could be walking through the back door right now, and the back door's open, and somebody walks in, and all the jurors look. And the defense lawyer said, the fact that you looked is reasonable doubt. So anyway, I don't think it worked, but whatever.
Well, when that door swung up, I mean, it was a
Does
moment.
make-
It was a
does make
moment
you
there,
wonder.
but yes.
All right, let us know when you find
Yes,
confirmation.
Your Honor, thank you.
Then let's go ahead and bring out that inmate. So. Mr. Talbot, what do we have?
Thank you, Your Honor. This is Mr. Cody Lewis. He's set for a VOP hearing today.
Okay.
Mr. Lewis would like to apply for recovery court. May we please reset this 30 days to the next VOP date?
All right, let's put it on June 29th. Is it?
I just heard you that.
This was just issued this morning, so
Then I'm going to represent.
give this, if you will, please, to Mr. Talbot.
Received, Your Honor. I acknowledge receiving this and waive formal reading of the same and enter a plea of not guilty on behalf of the defendant.
Plea not guilty is entered. We'll set it for the June VOP day, which is June what? June 29th.
June 29. Thank you, Your Honor.
All right. I'm going to go back to page 3, 2025 CR 162, State versus Christopher Aaron Carson. Ms. Stevens, you have a motion for the bonding company in that case? Let me pull that file. Hold on just a minute. All right, Your motion states that the defendant was arrested and charged with being a fugitive from justice and incarcerated in the Sumner County Jail.
Yes, Your Honor.
And then on April the 28th, he was extradited and transported to Berrien County Jail, Berrien County, Georgia. And
Yes.
he remains there on a felony probation violation.
Yes, Judge.
And pursuant to 4011-139, you're asking to be, that the bonding company be relieved.
Yes, Your Honor.
Does the state have any opposition to the motion?
Not that I'm aware of.
Well, by statute, once he is arrested and taken into custody on a case, you have the right to be removed from jail, from the bond, I think. Let me look at that statute again.
Yes, Judge.
The interesting part of this is that there's been no forfeiture of his original bond in capias for his arrest, because I think it was not set until February, let's see, I'm sorry, it was set for June 17th, 2026 for status. Under the statute,
He's been in Georgia since April, Judge.
I represent Mr. Carson, and I'm not sure, is he incarcerated in Georgia? He was definitely released from the jail here, it was 9th of April.
He bounced us, oh, didn't.
the statute deals with the forfeiture of bail having to do with a forfeiture having been taken. It doesn't really apply where there's been no conditional forfeiture of the bond. It may be that your bonding company is asking to be relieved to avoid that, but I don't know how the statute would allow him to. They made the bond an accepted payment from the defendant. Then they're now asking pursuant to 4011-139A, which states that if the defendant whose release is secured under 4011-122 does not comply with the conditions of the bail bond, the court having jurisdiction shall enter an order declaring the bail to be forfeited. That means we would forfeit your company's bond. Notice of the order of forfeiture shall be immediately sent by regular mail by the clerk of the court to the defendant at the defendant's last known address. The defendant's surety will be served with sara facie upon the forfeiture and entered, and a capias shall be issued for the defendant. When the defendant who failed to appear pursuant to the conditions of bail bond is arrested on a capias, the surety on the defendant's forfeited bond is released. All of that contemplates the fact that there's been a forfeiture, and there hasn't in this situation. That may happen, but at this point, I think your client's motion is premature because there's been no forfeiture entered.
Yes,
So
Judge.
we need to try to get him back.
Yes, Your Honor.
So
Thank you, Judge.
anyway, their motion to be relieved is denied respectfully because it doesn't meet the conditions of the statute. There obviously may be reapplying at a later date. but-
Yes, Your Honor.
Judge, I think Mr. Howard and I were under the impression it was in our, so that's.
You what now?
We were under the impression
found out last week.
All right.
Thank you, Judge.
You had another matter?
I have two more, Your Honor. I
Are
have
they
an-
all basically motions to relieve a bonding company?
The Walton, Your Honor, I think that's on Your Honor's last page, Chase Walton, that is correct. It's a motion to be removed. And the fact pattern is the same, although he's not in Georgia, he's in Hickman County at this time.
There being a conditional forfeiture and under that statute that I just recited into it, your client would be entitled to relief, so as he's been picked up in Hickman County.
Yes, Your Honor.
You'll submit an order, please. I'll find that the bonding company is relieved and the defendant will be held without bond.
Thank you, Judge. You have it?
Ms.
Perfect.
Stevens, if you'll sign off on the order.
Thank you.
Mhm. And then your other one,
McCoy, Your Honor, he is incarcerated. I think he's been brought up to
Ronnie
plead.
Tosh McCoy.
Yes, Judge.
And that's, again, another motion to be relieved.
No, Your Honor, he's for plea.
Oh, he's your client.
Yes, Judge.
Is he here?
He was set for Zoom originally, but I believe that he was going to be
Then we're
transported.
gonna bring him down for you. He hadn't been brought down yet? All right. We'll try to get him here as soon as we can. It'll probably be likely after lunch now, so.
Your Honor, I have to be in Montgomery County at 1:30 today, but I will come back as quickly as possible.
I'm not sure we'll still be here at one, if you go to Montgomery County at 1:30.
The abyss, yes, Judge, it's the mini Davidson County. I loathe it, but there I'll be.
We do have 4 pleas for tomorrow
I'll make it work, Your Honor, if you would allow that.
to move it to tomorrow. I have to leave at lunch tomorrow.
I will be here at, I've been up since 3, Judge. I can be here at 04:30 tomorrow morning if the court is available. I'll be here.
You could be here at 4:30, is that what you said?
04:30? Oh, 4:30 in the morning, Judge, but I can be here anytime you ask me to, Your Honor. I would like to get him pled out. It's been a while.
Then let's, we'll move Mr. McCoy's to tomorrow morning at 9 o'clock.
Yes, Judge. Thank you, Your Honor.
But it is for plea.
Yes, Your Honor. He just needs to sign. Oh, that's the other thing.
Do you want Mr. Flanagan's?
Well,
You know Ronnie Tosh.
Littleton always volunteered a lot.
I do.
But I think this defendant's in the same conspiracy case that I am.
Problem with having lawyers stand in, which we do all the time, is that occasionally you'll get someone who is upset about the fact that their real lawyer is not, their actual lawyer is not there with them, so.
No, Judge, I don't mind coming back in the morning if you'll allow that.
Do what?
I can come back tomorrow morning. That's
Tomorrow
totally.
morning will be all right.
Yes, Judge.
We'll do it at 9
Perfect,
o'clock.
09. And, Your Honor, there's also another matter, Miss Crystal Wilkerson's case, Mr. Dillard.
Speaking of those type situations,
Yes, Judge, I was just asked via text to stand in to get a new date, but I don't know that that's actually the
do you
case.
have the agreement that was executed? We started the plea, I think, at a prior date, started the plea, and he was unhappy with the fact that Ms. Wilkerson was not there and expressed some issues about that, so.
I spoke with her client this morning briefly and explained I did receive it, Ms. Bryson sent it to me in my text, so he was able to read it and said he did not want to accept that. So I explained to him that
But he does not want to accept the plea.
that is what he told me,
All right,
Judge.
then we need to set him a trial date.
Yes, Your Honor.
Let's bring it, do you have Dillard here?
Yes, Judge.
Bring him out, please. So we haven't heard anything from Houston County about Mr. Nicholas Hardin Creech for arraignment? Good morning again, Mr. Dillard. We are here today for a final plea day on your case, and it's my understanding, talking to Ms. Stevens, that you have seen what your lawyer has been offered by the state to resolve your case by an agreement, and you decline to accept it, which is your right. So I'm going to set you a trial date. And General, do we know, this is a drug possession charge. Do we know when you want to set this?
It is probably a 3-witness trial, so it would be a 1-day trial.
Well, let's, we have State versus Cordarius Godwin. What about the State versus Richard Greer? Mr. Flanagan, is that case a go for sure? You want to set it behind the State versus Richard Greer?
What day is that, Judge?
September the 28th and 29th. You can put it on the 29th, that would be the second day.
That's fine, Judge.
All right, this case will be set for trial on September the 29th.
Thank you, Your Honor.
Who else? Let's bring out the next inmate. Let's try to get these inmates taken care of.
Kang Nguyen, also known as Andy Latran. Reset him from last month, attempting. What is going on? Mr. Nguyen was being supervised in Oklahoma for our VOP. He got new charges in Oklahoma and has resolved those, but he would like his probation officer originally supervising him in Oklahoma to testify at his hearing. We have been trying to hunt this person down. He is no longer employed by probation in Oklahoma, and Mr. Miller, my investigator, is having a rough time of it. Mr. Nguyen is very adamant this person testify. I don't know how long it might take us to find him at this point. I'd ask that we reset this a couple of months at this point.
Well, let's see, this is June. You'd be looking at, next is June. You'd be looking at July. What is your date in July? Yes. July 27th. All right, thank you. Anybody have anything that doesn't require an inmate that we're waiting on?
Your Honor, on page 5 of the docket, there is State versus Jack Dudley. This is a case where the defendant's presence was excused. He's incarcerated in Benton County. On this, he's got pending charges in Davidson that relate to the alleged violation in this case. We'd ask that the court grant a reset to the September VOP date, please.
September 30th.
Yes, sir.
All right, we'll reset it September 30th.
Thank you, Your Honor.
Patrick Meadows, who was downstairs, I don't know if he's been brought up here at this point. He is on this one? Well, if you want to wait, we can wait and get him out here, but we were gonna reset him.
What are you doing with him?
The basis of his VOP is the case that was in sessions this morning, which has been bound over to circuit court, and ultimately, I think we'd like to explore mental health court from Mr. Meadows when that gets up here.
All right, so when do you want to reset him?
Judge Turnbow's next docket
is
would
the
be
mental
the
health judge. So.
August, so.
Is he here in August? Turnbow? So that was August 27th? August 31st.
Very well, thank you.
We do not need Mr. Meadows. They can transport him back to the jail. Anybody else have anything that doesn't involve an inmate?
I didn't realize.
You're right. We do need him. Mr. Baker? All right. What is it? Well, the reason it was reset, there was nothing to indicate why you need an extension. There was just basically it was a petition for an extension with no correlating evidence. If you want to tell me why, then let us place you under oath and we'll let you do that. So raise your right hand.
Yes.
Well, at this point, there was a final forfeiture or conditional forfeiture, is that what it was? This says for an extension of a final forfeiture. When do you know anything about what's going on or why you need an extension?
Well, I put in for the extension a month before the forfeiture. I didn't want to do it day of the forfeiture.
Well, there was a conditional forfeiture that was issued in January of this year, and that normally we set it 6 months down the road.
For June 17th.
That would have been somewhere around that, yeah. But we granted an extension of your final forfeiture for June 17th of this year. The final forfeiture was originally in January, and then we reset it for June. So all I needed to hear from you is, are you making any efforts to locate him?
Yes, sir. Yes.
How long do you think that you need as far as an extension?
I wish I could tell you. I would love to tell you 90 days.
Well, how about we say
I am in search of him, though. I'm working with his sister to try and locate him.
I'm going to give you till January to see if that takes care of it, which is about as good as I can do right now. We'll reset it for January 27th.
Thank you, Your Honor.
All right. So as soon as we can get an inmate to bring out, I'm waiting on them, so.
This is Mr. Patrick Meadows.
Mr. Meadows is here to be arraigned on an second amended violation of probation. And I believe we've given you or will give you a copy of the amended charge. You want a formal reading of that?
No, sir.
All right.
And if we could just keep him set on August the 31st.
We're resetting it for August 31st in front of Judge Josh Turnbow.
You'll probably have a court date. It's going to be an arraignment on that go once we get them all up here. So. Acknowledge receipt.
According to my list, it'd be Joshua Ray is next. Is that who? Mr. Peters, you are here to be arraigned on an indictment charging you with violation of the sex offender registry on 3 different counts. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, please.
All right, I'll appoint the public defender here in the office to represent you and give them a copy of that charge.
We accept the appointment, acknowledge receipt of the indictment, enter a plea of not guilty at this time.
Plea of not guilty is entered. We want to set this for status in September the 23rd. Ms. Lowe, are you going to be ready on Mr. Bradford whenever we can get him out?
I still have to speak with him.
Do we know if they've transported Nicholas Hardin Creech or if he was supposed to be on Zoom?
Your Honor, this is Mr. Joshua Daniel Ray. He also needs to be arraigned on an amendment this morning, I believe.
All right, this will be a violation of community corrections, is that correct? All right, we have a first amended. We'll give you a copy of that to serve on Mr. Ray, or give him a copy rather.
Acknowledge receipt, and we waive any reading, Your Honor.
All right. Plea of not guilty is entered. Do you want to set it for that June date,
That would be fine, Your Honor.
which was June 29th? I don't know why I can't remember that. June 29th.
Thank you, sir.
Thank you. Mr. Baker, do you represent John Allen Wren? What happened to Mr. Baker? Sorry. When I finish with Mr. Wren, we'll break for lunch. Anybody that needs to talk to their client, this would be a good opportunity to do so. You bring out Mr. Guthrie?
Just need him to sign, and then I'll pass up the sheet.
All right.
I dealt with Miss Sarah on that.
So by my count, we have 5 cases for plea tomorrow. Now, we had 4 and we've added 1 today.
We're gonna get your jail credits.
Mr. Flanagan, what else do you have?
He's got a medical condition. He takes medication. He was here in general, so he was here this morning. 1 or 1:30.
Let's do 1:30.
Back with him.
All right, I've been handed a document indicating that Mr. Anthony Cooper Guthrie, who is on page 8 of the docket number 2019 CR 337, on a charge of probation violation, that he is going to waive a hearing and admit his violation, be revoked on his probation, and put his sentence into effect with credit for all time served. Is that correct? All right, raise your right hand, Mr. Guthrie.
Ma'am.
State your full name for the record.
Anthony Cooper Guthrie.
Mr. Guthrie, you're here today on a charge of probation violation. I want to make sure you understand what your rights are. Do you understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, sir.
You understand you would have the right to have a lawyer and to have one appointed if you cannot afford your own?
Yes, sir.
You understand that if you had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes.
Do you understand that by pleading guilty, you're waiving your right to that hearing and to that appeal? All I'm going to do is revoke you to serve your sentence and make sure you get credit for all your time.
Yes, sir.
Is that what you want to do?
Yes, sir.
You understand all your rights?
Yes, sir.
Are you pleading guilty to your probation violation?
Yes, sir.
Then upon your plea of guilty, I find you guilty, or that you be revoked to serve your sentence with credit for all your time served, and we will make sure that you have an order entered supplying with all the correct time, okay?
Yes, sir.
All right, thank you.
Thank you. Thank you, Mayor.
All right, we're going to then break for lunch. We'll be at lunch until 1:30. You snooze, you lose, Mr. Baker.
All rise. This court's in recess until 1:30. This is in recess.
All right, now can you hear me?
Yes, I can.
All right. Are you Nicholas Harden Creech?
Yes, ma'am.
Mr. Creech, you are here today. We need to arraign you on an indictment here in Dickson County that has charged you with aggravated assault on a law enforcement officer, evading arrest with a vehicle involved, reckless endangerment, assault with bodily injury, evading arrest, resisting arrest, driving with your license suspended or revoked, and criminal impersonation. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, I do.
All right, I'm going to appoint the public defender who's here in the courtroom with us. Mr. Talbot, Mr. Creech is here today and has filed a number of pro se motion or a pro se motion for a bond and a source hearing modification filed by him on a pro se basis. Let's first of all go ahead and do the arraignment.
Yes, sir. I acknowledge receiving a copy of the indictment in this case and waive formal reading of the same, and on behalf of the defendant, enter a plea of not guilty.
Plea of not guilty is entered on behalf of Mr. Creech, and we want to set a status date.
He's
By the 16th, he's called with, so I would suggest we add him to that date.
All right.
That's
Well,
fine, Your
I
Honor.
think the arraignment date is
that would be the last day for a plea.
That's the plea date, Your Honor. Yes,
All
sir.
right. Plea day will be July 13th. The trial date is July 16th, and we'll set these cases on that same date.
I think that's what we, right.
So I presume she'll take pleas on that date.
As far as these motions go, I'd like to speak with Mr. Creech before he proceeds on anything.
All right. Mr. Creech, I think it's advisable for you to talk with your lawyer about this situation, especially since there's already a case set for trial in July. So we're just going to pass your motions without prejudice to let the public defender talk with you about your situation, okay?
Okay. Okay.
I'll be in contact with you, Mr. Creech.
Mr. Talbot will be in touch with you as soon as possible to see what he can work out.
So what about the bond hearing?
That's what I'm talking about. You have a pro se motion for a bond, and if Mr. Talbot is recommending that you let him talk with you before we have that hearing, normally we would not have that hearing until after you've been arraigned anyway.
I'm going to come talk to you about your bond motion
Okay, when, do you know when that'll be?
as soon as I can.
Can't give you a definite date because he's got to be in court with me today and tomorrow, but he'll be there as quickly as he can, and then he'll start something in the motion to try to get you.
Your Honor, I filed this bond reduction, this hearing for this bond on this. One of them's for the circuit court for failure to appear, and the other one's for this indictment that would come up from general sessions. And I filed this bond reduction, this motion before the source hearing over a month ago. I was skipped over 2 weeks ago because they forgot to transport or forgot to come to Zoom court. And then I've got a real bad family situation. I got a bond. I need to get this bond reduced so I can bond out and get my affairs in order. And so I've been sitting here for 3 months now, awaiting this right here, to try to get something done on this. So, I mean,
I'm going to let you talk with him, but I'm going to, if you want to.
I'm trying to get this bond reduction done today.
If you want to talk with him.
Perhaps I can, oh, sorry, Your
Then
Honor.
we can, I'll give him a bond hearing.
Yes, Your Honor. Perhaps I can join his Zoom link with Houston County there.
I'm going to exit him out of this one and let you just, there in Houston County, I'm going to take him out of this hearing and let Mr. Talbot come and talk with him by telephone or by Zoom, and then we'll come back to you. All right.
Yes, Your Honor. Thank you.
All right, who else do we have? All right. So I had accepted the plea, and this is for sentencing portion of the case.
Yes.
All right, then we'll resume this hearing. This is State versus Tomas Zurich in 2026 CR 131. All right, then resuming the situation, we had gone through all of the rights, and I believe the last thing I'd ask you is if you understood everything I explained to you during the explanation of your rights, and if you were satisfied with your attorney's services.
Yes, I am.
Mr. Flanagan, do you know of any reason he should not enter this plea?
No, Your Honor.
Anything further from the state before I pronounce sentence?
No, Your Honor, we did the factual basis with him asking him questions. Misdemeanors only, so I believe the factual basis has been covered.
All right, then Mr. Tomas Zurich, upon your plea of guilty to count 1, driving under the influence, find you guilty, sentence you to 11 months and 29 days in the county jail. That will be suspended all but 2 days to supervised probation. The loss of license will be for 1 year, $350 fine and cost. You'll have to attend either the Victim Impact Panel or the DUI school. You will have a requirement of an interlock device. He may use the DUI Education Center for his initial 48 hours if he chooses. This will be served consecutively to 2023 CR 273. And we need a date when he's going to report, or do we have to set a date for him to report to that DUI center?
Your Honor, what we typically do, it takes about 6 weeks to get an actual weekend, and I realize it takes time. So my rule is, in the first 30 days since pleading, get on the schedule in the next 30 days. Then he'll work with probation just to ensure he does it. As long as he's scheduled in the next 30 days, I think that's.
All right.
There's 2 cases, by the way. There's 2 cases he's pleading to.
All right. In 273, then he is found guilty, sentenced to 11 months and 29 days, except for 48 hours, suspended to supervised probation, loss of license for a year, $350 fine and cost, Victim Impact Panel or DUI school. Interlock required, may use the DUI Education Center for the initial 48 hours, and that'll be up to him to schedule that within the next 30 days. All right.
And Madam Clerk, I think the restricted license orders are also.
I have it here before me. All right, thank you. He needs to see the probation department before he leaves. All right, any inmates that we have that need to bring them up, please. Mr. Nixon. Joey Adarez Nixon. This is on a violation of probation. Mr. Nixon, was he placed under oath? Mr. Nixon, you have filled out an affidavit of indigency. I'll take a look at what you have. You may want to come around this side to avoid having to reach over Brandon. You make $3,250. What is that, weekly, monthly, or what?
Monthly.
What is it that you do?
Production operator, work in a factory.
Well, that's over $36,000 a year income, and therefore I do not find that you're indigent, and therefore I decline to appoint you an attorney. And you may, if you come in and produce verification that you've sought counsel with attorneys and have been unable to hire one, then the next judge may reconsider that. But at this point, with that type of an income, you do not qualify as indigent. All right. He's previously been set for June. When you come back in June, you need to be prepared to show the judge that you've attempted to hire a lawyer.
Okay,
All right, thank you.
thank you.
Judge, up next is Tierra Bethke.
Your Honor, this is Ms. Tierra Bethke, and she is going to, subject to the court's approval, resolve her violation of probation case today with the following agreement. She will admit the violation and waive her hearing. Her probation will be revoked, and her sentences are going to be put into effect. She has significant jail credits that are noted on this plea sheet, and I'm going to have Ms. Bethke sign where it says defendant. Okay, there you go. Can you get a copy? Well, we're going to hand it in now, and so what I'll have to do is ask the court to send us a copy after it's entered.
All right, Ms. Bethke, raise your right hand and let's place you under oath.
Yes.
State your full name.
Tierra Lane Bethke.
You can put your hand down now, thank you. You are here today on a probation violation. I want to make sure you understand your rights. Do you understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, sir.
You understand you would have the right to have a lawyer and to have one appointed as we've done with the public defender?
Yes, sir.
You understand that you would have the right, that if we had that hearing and I found you guilty, then you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by pleading guilty, you're waiving your right to that hearing and to that appeal? All I'm going to do is order that your sentence be put into effect and give you credit for all your time.
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to go ahead and enter a plea of guilty according to this agreement?
Yes, sir.
You want to go ahead and plead guilty and put your sentence into effect?
Yes, sir.
Okay. Then I find you guilty, order that you be revoked to serve your sentence with credit for all your time. And your lawyers put on there all of the dates that you're entitled to, okay? All right, thank you.
Judge, up next is going to be Connie Presley.
Judge, we're in the process of getting some medical records for Ms. Presley, so I'm going to ask the court for a new date on her, and I need to see her in the back to get her to sign some releases for me.
June 29th? June 29th? All right, reset for June 29th.
Thank you, Judge. If I may come on back in the hallway there. Thank you. That's all I have, Your Honor, if I may be excused.
You may.
Judge, up next is going to be Ray Dorman.
You're good, you're good. Your Honor, this is Mr. Ray Dorman. Subject to the court's approval, he will settle his case, which is here before this court by information today. A negotiated settlement was arrived upon in General Sessions Court, so we're here today. Pursuant to the information charging a DUI fourth, Mr. Dorman will plead no contest to the offense of DUI fourth, a Class E felony. His punishment will be 1 year TDOC at range 1, suspended to state probation. But for the 150 days jail that he must serve, he'll have credit for time he's already served. There will be a $3,000 fine, license revocation for 8 years. He has in-person reporting as a condition of his probation, and if he has any other cases, any other sentences, this would be concurrent with that. And then he has jail credits reflected on this plea sheet, and he's going to sign where defendant has indicated. I can move it down. Yeah, I can move it, how about right there? We'll use that right at the edge right there. And then, Your Honor, as well, there is a notice of DUI punishment, which I have gone over with Mr. Dorman, and he's going to sign and date that as well. I'm gonna move this after this, so you, there we go, that's probably better. Today's May 27, 2026. Yes, sir. All right. Okay, and I'm signing as your lawyer. Now, I believe that there is also a information which the defendant will need to sign as well.
I think I have it right here.
Yes, sir.
Right.
One more. So this is the information we talked about. This is where you'll sign as a defendant right there. Again, I'm going to try to find the very edge here of this podium. Good to go. I've already signed it. Prosecutor signed it. This waives the indictment process, so we can settle your case quickly. The court's going to
All
ask
right,
you some questions.
Mr. Dorman, raise your right hand. Let's place you under oath. Thank you. Step up to the microphone there. State your full legal name for the record.
Ray Osro Dorman.
Mr. Dorman, you're here today proceeding on what we call a criminal information. I want to make sure you understand what that is. I know your lawyer has done a good job of explaining it. Every person who is charged with a crime that carries the possibility of incarceration has an absolute right to have the evidence against them reviewed by an independent body called the grand jury of that county to determine whether or not they find probable cause to believe that a crime has been committed. You have the right to expedite the disposition of your case by waiving that, by entering a criminal information and waiving the grand jury step. And that's what's happening today. Do you understand that's what you're doing?
Yes, sir.
Do you understand that we'll proceed here as though it'll be the same as if you had gone through the grand jury? We're just skipping that one step. You understand that?
Yes, sir.
Do you understand what you're charged with, that you're charged with driving under the influence on a fourth offense, which is a Class E felony?
Yes, sir.
You understand what the evidence is against you, and have you and Mr. Talbot had a chance to talk about it, discuss the range of punishment you're facing, as well as any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter this plea of nolo contendere. That simply means you're not going to admit you did anything, but you're not going to contest the state's evidence, and they'll tell me what their evidence would be if this case went to trial, and that's the evidence I will use to find you guilty according to this agreement. You understand that?
Yes, sir.
Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury in this court?
Yes, sir.
Do you understand that trial you would have the right to have a lawyer and to have one appointed, as I've done with a public defender?
Yes, sir.
Do you understand that at trial you'd be presumed to be innocent until such time, if ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that at trial, you and Mr. Talbot would have the right to confront and cross-examine every witness the state called to testify against you, and you can bring in your own witnesses by the use of a subpoena?
Yes, sir.
You understand that you would be presumed to be innocent, you would not have to testify or prove anything at trial, and no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
You understand about if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by pleading no contest, you're waiving your right to the trial and to the appeal? All I'm going to do is approve what your lawyer has worked out. But you understand and have that this is going to be on your record to make more severe the punishment you will receive if you're ever again convicted of a crime.
Yes, sir.
I've been handed a document called a Notice of DUI and Punishment that your lawyer has indicated you and he have gone over. Is that your signature on that document?
Yes, sir.
Do you believe you fully understand how every case, every conviction carries a greater punishment the next go-round?
Yes, sir.
Any questions about that form?
No, sir.
All right. Do you understand, or rather, is your decision to enter this plea voluntary?
Yes, sir.
Anybody forcing you to do this against your will? You
No, sir.
understand I can't accept your plea unless I'm satisfied that you are guilty and that the facts support it. You understand that?
Yes, sir.
I need you to answer out loud on the record rather than just nod your head. All right, then I want you to listen as the state tells me what their evidence would be if this case went to trial, please.
Yes, sir.
Statement show that on or about May the 11th of this year, Officer Lefevre with Dickson Police initiated a traffic stop on a vehicle operating Mr. Warman speeding in the city of Dickson. Officer Lefevre noted signs of impairment for Mr. Warman, including the smell of alcohol. This warrants that he did not have anything to impairment. Used by sample blood testing. Humphreys.
All right, Mr. Dorman, I'm not asking you to agree with those facts, but you understand that's what the state's evidence would be if you went to trial?
Yes,
You
sir.
still wish to plead no contest?
Yes,
Are
sir.
you satisfied with your attorney's services?
I am.
You feel like Mr. Talbot's done a good job of representing you competently?
Yes, sir, I do.
Mr. Talbot, you don't have any reason he should not enter this plea? Anything further from the state? Then Ray Osro Dorman in docket number 2026 CR 148 upon your plea of nolo contendere to DUI fourth offense, I find you guilty, sentence you to 1 year in the Tennessee Department of Corrections. That will be suspended to state probation after service of 150 days in jail. Credit for time served, you're ordered to pay a $3,000 fine. Your license to drive a vehicle is revoked for 8 years. You must report in person, and this will be concurrent with any other cases that you may have. Thank you.
Thank you, Your Honor.
All right, who do we have next?
Up next, Judge, is Jason Bradford.
Judge, Mr. Bradford intends on entering an agreement. I believe that he is to be arraigned still on the second amended violation, is my understanding. And
Do we have a second amended violation of community corrections? All right, if it was just filed today, we'll need to go ahead and we need to serve him with it, and then we'll give him a copy at the arraignment. To arraign you, this is alleging you were placed on probation on or about July 27th, 2022 for probation violation. You were transferred to community corrections, and that the original charges were child abuse and under 8 years of age and neglect. That's what he needs to be served with. And it's alleged you violated your community corrections probation by violation of Rule 2, which states you would report to your officer on a regular basis, that you have not reported to Dickson since May 18th of 2023. Show that he has been arraigned, the plea of not guilty is entered, and we will set him for the June 29th. Pardon? Oh, you do today? Okay,
Yes.
that's fine.
So Judge, on the violation, amended violation and second amended, Mr. Bradford intends to plead guilty to those. The punishment for that plea will be to serve 6 days or 6 months, day for day, with credit for his time served, and then reinstate community corrections for a period of 10 years, beginning upon his release from the county jail. He's to receive jail credits from February 5th, 2026 to current, and community corrections credits from July 27th, 2022 to May 23rd, 2023.
All right.
Oh, have you summary?
Judge, just to clarify, although that's correct what she stated, he's going to be reinstated, but he's going to restart his entire
So he'll be restarting his entire sentence of 10 years? All right.
after he serves his 6 months.
Mr. Bradford, raise your right hand. Let's place you under oath. State your full name for the record. Mr. Bradford, you're here today on a violation of your community corrections probation. I want to make sure you understand your rights. Do you understand you have a right to plead not guilty and to have a hearing here where the state would be required to prove to the legal standard that you had violated your probation? You speak up because we're recording this. Do you also understand that you would have the right to have a lawyer and to have one appointed if you cannot afford your own?
Yes, sir.
Do you understand that if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand that by pleading guilty, you're waiving your right to that hearing and to the appeal. All I'm going to do is approve what your lawyer has worked out with the state.
Yes, sir.
And do you understand that that's going to require you to serve 6 months day for day with credit for time served and then reinstate you to community corrections to restart your 10-year sentence?
Yes, sir.
All right. Do you understand everything I've explained to you?
Yes, sir.
Do you want to plead guilty according to that agreement?
Yes, sir.
And upon your plea of guilty, I find you guilty of violating your community corrections probation, order that you be revoked to serve 6 months day for day with credit for time served. Upon your completion of that 6-month sentence, you will then be reinstated to community corrections for a period of 10 years, which is actually restarting your 10-year sentence. That will begin upon your release. All right. Thank you.
Judge.
Judge, up next is John Rune.
Mr. Talbot, can I see you for a second?
Never.
We're gonna set it up to do him in the morning. So that would be, yes, we'll do it on Zoom. Well, that's fine. If you know, we have the Zoom link already in place for tomorrow. So just give him that Zoom link. All right. Mr. Wren?
This is Mr. Wren, Judge. We have a motion pending before the court. If you recall, I think we were here last week. This was the case where Judge Turnbow, the state had filed a motion to revoke his bail. Original bond was in place. There was, I believe, two sets of charges by the General Sessions Court that triggered a motion by the state to revoke the bail on the first set of charges, which I'm still not sure that Mr. Wren had notice of that hearing. But that being said, he said, well, Judge Turnbow said, well, file a motion if you would like to have a hearing on it. Here we are, Judge. So I'd call
So
Mr.
you want to go in front of Judge Turnbow then?
I'd rather not.
Repeat everything you just said to me about how this has gotten in front of me.
Judge Turnbow, last month, I guess the state had filed a motion to revoke the bail. Mr. Wren, I'm not sure whether he was aware that they got the motion. They filed the motion while he was incarcerated. He made bail on the new charges. I don't think he even received the motion that went to the jail. I come to court because I had Mr. Wren on the initial case, which they were trying to revoke the bail on. And of course, Mr. Wren was not there, obviously. I don't think he had notice. And Judge Turnbow said, well, I'll revoke the bail and issue a capias, and, pick them up, you can file to have a hearing on it. So here we are.
All right.
I'll call Mr. Wren, Judge.
So you're asking me to set aside what Judge Turnbow did?
Well, either set aside or reset the bail compensate with the situation. Either.
And you're calling Mr. Wren as your witness?
Well, I guess I'm gonna have to go back through the 118 factors, but if you would like to hear those.
I'm here to hear whatever that Judge Turnbow has now stuck me with to hear. So,
Okay. I'll call Mr. Rand to the stand.
Mr. Rand, come around here, please. Have a seat.
Mr. Rand, if you would state your name for the record, please.
John Allen Wren,
Mr. Rand, where do you live and how long you live there?
124 Oakwood Circle, Dickson, Tennessee. I lived there 21 years.
All right. Were you born in Dickson County?
Yes.
What other family members you have living in Dickson County?
My mother, my brother, my children, several cousins.
Where's your children live at?
White Bluff.
Are you married right now?
No, of
Okay.
course.
All right, and Mr. Wren, have you ever been diagnosed with any medical or mental conditions that would affect your ability to understand court and come to court and so forth?
No, sir.
Okay. And Mr. Wren, have you ever been charged with failure to appear?
Never, no, sir.
Okay. Have you ever, knowingly failed to appear?
No, sir.
Did you get the notice of the bond revocation motion that was at the jail before you left?
No, what do you mean?
Did you get any mail that said,
No,
hey,
sir.
we're filing a motion to revoke the bail, be here on a certain date?
No, sir. Just when they just brought to me the revoke. They sent me the revocation after I was in jail. After it had done been to court.
Okay, you got it after you've been.
Yeah, they served me a warrant, yeah.
Okay, all right, now, Mr. Wren, what's your prior criminal record look like now? I'm talking about convictions, not what is pending.
Just what's been in?
Yeah, no.
Oh,
Everything
prior.
is- Yeah, what you've been convicted of, not what's pending.
I had a theft charge back in 1995.
Okay, other than
Something like
that,
that, something like that.
other than that, what else would you have convictions for?
Nothing.
All right, well, that 95 conviction, was that a felony?
Yes, sir.
It was a felony?
I believe so.
All right. Did you go to court on all those?
I did.
Did you complete that sentence?
I did.
No probation left, anything?
Nothing, no.
Okay. And did you post bail on the subsequent charges you got in the city of Dickson?
The charges now?
The charges that were triggered this revocation?
Yes, sir.
motion?
Yes, sir.
All right. Do you recall how much the bail was on those?
It was reduced down to $24,000, the first charge, the one they revoked.
Okay. And then the next one?
47,000.
All right. But you've made those, and then you know how much the original bail was in this case?
Which ones?
The ones
Sorry.
right here that got revoked, this bail.
The 24,000 was original from, that I've been going to court on last year.
All right. So the general sessions cases, how much were they?
They had doubled them. They said they doubled the charges, so they were the 60 and a 35,000.
All right, so they doubled.
They were doubled, yes. They were doubled from the original.
Judge, I'll pass a witness.
John?
Mr. Wren, are you certain you've only got one felony conviction on your entire history?
To my knowledge, yes, ma'am.
So
I've
if-
only been there, I've been on probation for it, yeah.
So you don't have 13 prior felony convictions for burglaries, thefts, et cetera? Lots and lots of those. You don't have any, you're saying that you don't have those?
Whatever I had was, like I said, 1995. I don't have anything else.
In fact, it looks like you were convicted in,
Is that an objection, Mr. Baker?
No, I didn't understand what you said.
Oh,
Well,
that's-
neither did I, but it's not a basis for an objection. Be seated.
So would you be surprised to see that your criminal history shows 13 felony convictions?
Would you ask, can I ask from when?
From a time period of 1997 to 2002.
I would. I was just convicted at one time.
Okay. And you violated those probations, didn't you?
No, ma'am.
All right. I don't have any questions for Mr. Rim.
You have a redirect? Now you can ask him what he says.
What was that answer?
To which one? I'm sorry.
He may not remember the questions.
I don't even know if I remember it at this
Well,
point.
I think what was said was, she asked if I had other convictions, and to my knowledge, I was only on probation. I went to court one time, it may have been a couple of charges together, I'm not sure, but I was convicted one time, and I served community corrections for it.
Are you talking about one case, but it may have
It
had
was put
multiple?
together, I guess, but it was not, I don't recall it being to 2000, anything like that. I mean, I got a probation in 2002 or something like that.
Okay, but you don't recall, okay. But you would. if
And I
there's-
never was violated or anything.
All right, but what I'm getting at is you could have a case that had multiple counts, but you don't recall, you just remember there was
There was a few counts, but there wasn't a lot, though.
okay, fair enough.
You understand it's, your credibility is something I have to look at, and so
Yes,
I want to go over this with you to make sure I'm understanding and that you understand.
Okay.
The state has filed a notice of impeachment and range of punishment. It is alleged, and they have records to show that you were arrested or convicted of theft of property in Dickson County on May the 15th of 1998. I think part of your confusion is, in 1998, there were 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 convictions all taken care of at one time when you said they all rolled them all together.
Yes, sir.
Does that help your memory any?
Was it you, I was convicted in 1988?
Yeah, you would know better than me, but I'm looking at the records.
Okay, that may be right. That's a long time ago.
And that you had a conviction of theft of property in 98, that you had a conviction for theft of property again in 98, that you had a conviction for burglary in 98, that you had a conviction for theft of property of thousands to $10,000 in May of 1998, that you were convicted of auto burglary in 1998, and another count of auto burglary, that you had another conviction for burglary of other than a habitation in 98, and you were convicted of burglary other than a habitation, another count in 98, and you were convicted of theft of property in 98. And then it says those are the 10 that all got wrapped up together. But it also alleges you were convicted of theft of property in Dickson County in February of 2002. Does that ring a bell?
No, sir.
They allege you were convicted of burglary in Dickson County in 1992. Does that ring a bell?
92?
92.
I was,
That you were convicted of shoplifting, a misdemeanor shoplifting in 2015, 11 years ago. Does that ring a bell?
that does. The 2000, you said 1992? I'm sorry.
It also says you were convicted of the offense of patronizing prostitution in Shelby County in March of 2010. You remember that?
That was dismissed.
It was. It says you were convicted, but you're saying it was dismissed.
Yes.
All right.
I'm sorry, did you say 1992?
No, that one
On
was,
one of them?
there was a 1992 conviction of burglary, according to this document. You understand that the state
Yeah,
will
that's-
have copies of all convictions.
Yeah, but I was 15 in 1992.
Okay,
When I wasn't.
all right. State have any other questions? You want to ask him any questions based on what I asked? Step down. Mr. Baker, you may call your next witness. State have any proof you wish to offer? Sergeant Anderson, if you'll come around, please. Would you hand me that? Raise your right hand and face the clerk, please.
Will you state your name for the record, please?
Sergeant Ronald Anderson,
And where are you employed?
the City of Dickson Police Department.
Did you have an occasion to recently to come in contact with Mr. John Wren?
Yes,
And was that while you were on duty?
yes.
Can you tell us about, well, let me ask you this. Did you or another officer seek charges on Mr. Wren after your encounter with him?
Yes.
And do you know what those charges were for?
Multiple charges, including felon in possession of a firearm ×2, possession of illegal narcotics for resale with different types of narcotics, and some drug paraphernalia charges as well.
All right. Can you tell us, was this the date of April the 14th of 2026?
Yes.
All right. And can you tell me about the encounter with Mr. Wren on that day?
Yes. Our agency was dispatched to the area of Smoothie King located in the shopping centers on Thornton Drive for a report of a suspicious male subject.
You know, this is a bond hearing, and I think as to why he is reporting, it's not necessarily offered for the truth of the matter so much as a basis for why they were dispatched out and what they were looking for.
I'm overruling the objection. I'm allowing it in because it's being admitted to show why the officers took certain action rather than for the truth of the matter.
Go ahead.
I responded to the area for the reports for the call of service, and I encountered Mr. Wren sitting inside of a pickup truck matching the description of the vehicle that was called in on. As I approached the pickup truck to investigate, I noticed the driver's door was ajar. I saw Mr. Wren sitting in the driver's seat of the vehicle with a pipe in his hand and a lighter in his other hand. Through my experience, this pipe was indicative of smoking illegal narcotics. So in a clearly identifiable police uniform, when Mr. Wren noticed my presence, he tried to slam the door on me. So
Well, certainly, Judge, the fact that he...
This is a motion to ask me to set aside an order revoking the bond. The state is proceeding, I'm assuming, on the original revocation to show why it was justified.
Yes, Judge.
And it's also a motion for me to consider setting you a bond, but a first step is whether or not the court was justified in revoking the bond, so overrule the objection.
You can go ahead.
after Mr. Wren noticed my appearance, my clearly identifiable police uniform, and tried to slam the door on me, I had to force the driver's door open and order Mr. Wren to step out of the vehicle. Mr. Wren, with the drug paraphernalia that he was possessing at the time, began to try and tamper with said evidence and stash it inside of the truck as he exited the vehicle. He then physically resisted to the point that I had to grab him by the wrist and try to place him in handcuffs.
Sustained as to his answer, you may restate your question.
What did Mr. Wren do with the drug paraphernalia?
Mr. Wren turned away and tried to place the drug paraphernalia in the seat amongst a pile of items in the truck so it could be hidden.
All right, and Your Honor, obviously he can testify to what he's observed.
Overrule the objection.
And then when you attempted to, presuming at this point in time, attempted to get him out of the vehicle. What did John Wren do?
Mr. Wren, as I grabbed his wrist to detain him and place him in handcuffs, pulled his hand away from me and became argumentative.
Okay. Were you able to get him into custody?
Yes,
Okay. Did you then search, due to the paraphernalia? Did you search the truck?
yes.
All right. Did you find any other items besides the paraphernalia?
After Mr. Wren was taken into custody, when I went back to the vehicle to retrieve just the items that I noticed Mr. Wren in possession of, I then also observed other items of drug paraphernalia in plain view.
Such as, what did you observe?
The first item that I observed was a tray that had multiple clear baggies sitting on top of it, filled with a white powdery residue.
Did you locate any drugs in the vehicle?
Yes,
Do you recall, obviously they are, I presume they have been sent to the lab.
yes,
And do you have experience in observing drugs and determining by characteristics as to whether or not they appear to be certain substances?
yes.
All right. And what did these substances appear to be?
As I stated earlier, there were multiple substances, but one of the substances in most quantity was what I believed to be crystal methamphetamine.
Do you know approximately, based on weighing, how much that substance weighed?
At this time, I do not recall.
Okay. Do you know if it was, well, I guess Your Honor, may I approach with
You
the
may.
affidavit?
Your objection is what?
It's the affidavit, Judge, that's on the court's webpage.
Pass it to Mr. Baker and let him review it. At this point, we're not dealing with a discovery issue at a trial, but rather a preliminary hearing.
I'll let you finish reading that, and then when you're done, I'll grab it and you can tell me the amounts if you don't mind. Value or amount of estimated of the methamphetamine.
Judge, I'm going to object to this testimony from this
Were you present with Officer Kane when he did the report and filed the affidavit? And were you present during all of this interaction with Mr. Wren?
Yes,
And did you physically see the items that were recovered?
yes,
Were you physically, or not physically, were you aware of what it looked like and the amount that it was weighed?
yes.
I note your objection, overrule the objection. I think the document is sufficiently shown to be a document that he could use to refresh his memory.
You can answer.
The suspected methamphetamine that we located weighed 144 grams.
Did you locate any other drugs that appeared to be, any other type of drug?
Yes, we located what we believe to be crack cocaine, fentanyl, as well as suspected MDMA, or ecstasy for the street name.
Okay. Did you locate any weapons?
Yes,
What did you locate?
we located a .45 caliber Kimber pistol, and we also located a Mossberg 12-gauge shotgun.
Was there anything special about the Kimber pistol?
The Kimber pistol was, its serial number was ran through the national database as well as the shotgun. And the national database came back to show that the Kimber pistol had actually been reported as stolen.
Again, this is a bond hearing and it's reliable hearsay if it went through NCIC, Your Honor.
Overrule the objection.
All right. Can you tell us about the pistol again? I'm sorry.
Yes, the serial number on the Kimber pistol was ran through our dispatch, who ran it through the National Crime Database.
This is a standard police procedure as far as checking whether or not a vehicle or an item has been stolen. I find it to be reliable hearsay for purposes of a bond hearing, therefore I overrule the objection.
Was the pistol reported stolen?
Yes.
Okay. And is there anything unique? I'm not as familiar with the guns, but is there anything unique about a Kimber or Kimber pistol? Is that a nice gun?
All that I know is they are expensive.
They are expensive.
Now, Sergeant Anderson, Mr. Wren was charged with other crimes as well. And do you know where that case is, this April 14th case, in court? Is it in General Sessions Court, or do you know if it's been bound over?
As far as I know, it is still in General Sessions.
Okay. Do you know whether or not any digital scales were located in the vehicle?
I don't recall.
All right. I don't have any further questions. If you'll answer any questions of the...
Mr. Baker, do you have questions?
Officer, did you weigh this 144 grams of suspected methamphetamine?
Officer Smith did.
Well, then how do you know it was 144?
That's what the scale he used read.
Were you there when, did you watch it?
Did I watch him weigh it?
Yes.
No.
So you have no firsthand knowledge of this weight, correct?
Correct.
You don't know if the scale was tared, correct?
Scale we've used to weigh everything else, sir, but I do not know.
Do you know how to tear the weight out of a scale?
No, sir.
You don't. So you don't even know how to weigh drugs.
I know to turn the scale on and place the item on the scale and use a readout.
So you don't tear them, you don't calibrate them, anything of that nature?
No.
Sustained. Officer, pull that microphone slightly toward you. The base will pull toward you. There you go.
Now, why was who dispatched, I mean, who was the caller that called in the vehicle that sent the police out there?
I don't recall.
You don't recall, or you wasn't told?
I just don't recall.
Don't recall? Is it in your report? Did you make a report?
It should be in the report that Officer Smith wrote.
Were you the arresting officer or Officer Smith?
Officer Smith.
No further questions.
Redirect. Thank you, sir. You may step down and have a seat. State may call your next witness. Let's have you spit your gum out too.
Oh, sorry.
Will you state your name for the record, please?
Officer Jacob Brake.
And where are you employed?
I work for the City of Dickson Police Department.
Officer Brake, were you involved with an interaction with Mr. Wren on April the 27th of 2026?
Yes, ma'am, I was.
And can you tell us about the interaction?
I was a backup officer to Corporal Hollis's traffic stop with Mr. Wren and a female. When we got there, whenever I arrived as backup, there had been an altercation with Mr. Wren reaching into his pants trying to grab something. Whenever I got out of my patrol car, there was a white bag. There was a small bag with a white rock inside of it. He was ultimately detained and put in the back of a car when Agent Pirtle with the Drug Task Force deployed his K-9, which gave a positive alert to the odor of narcotics inside the vehicle. Upon a search of the vehicle, we located some paraphernalia inside, along with some other substances that were located on Mr. Wren.
All right, when you say paraphernalia, what was the paraphernalia? Do you recall?
Some crack pipes that were inside the vehicle.
Okay. And you were kind of soft-spoken when you were talking about the drugs or suspected drugs that were located. Do you recall what those suspected drugs might be, based on your experience as a law enforcement officer?
There was
Or what it
approximately-
looked like, I guess.
There was a brown substance that appeared to be heroin, and then there was a pink powdery substance, which what we won't know what it is until it comes back from the TBI, but we're assuming that it's fentanyl.
All right. And was there cocaine found as well, or crack? I think you said one rock.
Yeah,
Is that right?
I believe it was cracked. It was in a small baggie.
Okay. And was there anything else of note in the vehicle on that day?
Not that I can recall. There was a lot of stuff inside the vehicle. There was a lot of suitcases, clothes. There was a lot of stuff inside the vehicle.
So there were suitcases inside of the vehicle?
Yes, ma'am.
And you said another person was also with Mr. Wren?
Yes, ma'am, a female.
Now, the following day, April the 28th, did you get a search warrant to search the vehicle that Mr. Wren had been in the day before?
I did.
All right. And during that search, let me ask you this. You were granted the search warrant, is that correct?
Correct.
Okay. And during the search, did you locate anything additional in the vehicle?
Yes, we located some more what appears to be crystal meth, a digital scale, and some more of the pink powdery substance, I believe.
And do you know approximate quantities of the methamphetamine and fentanyl?
I would have to look back at my report. I don't remember an exact weight of that.
Your Honor, may I approach with the affidavit?
You may.
I will ask you that.
Okay.
What appeared to be methamphetamine and what appeared to be fentanyl?
Yes, the methamphetamine was in 2 bags, and it was approximately 10.5 grams. And the other bag was around 6 grams.
All right. And did you review information, statements by Mr. Wren in regards to getting this search warrant?
Yes, I've reviewed jail calls.
And what did Mr. Wren say in the jail calls that led you to get a search warrant?
I don't remember in quotes exactly what it was, but he was telling somebody.
This witness can testify as to his memory of what he observed in this court's opinion. Therefore, it's not a basis for him to be disqualified from testifying about it. but it is something that he can be cross-examined about whether or not his memory of that event is reliable. That's true. I'll allow you to respond if you want to on the record.
Judge, the response would be, these are statements made by Mr. Wren that led the officer to getting a search warrant, and I think it's relevant to explain basically the basis for it.
Overrule the objection. This is not a situation where the video is being played and an officer is along the way interpreting it for the jurors or the court to listen to. This is instead being allowed by this court to allow the officer to testify about essentially how they were able to go about getting a search warrant. And for that reason, his memory of what was said in that and how it led him to a search warrant. The search warrant itself would set forth those facts that you're objecting to. And if it gets to a point where that becomes more relevant and more essential, then that would be a question for the court to decide. Here is just a statement of what happened and why they took certain steps. And for that reason, I overrule your objection.
Did Mr. Wren make any statements on jail phone calls in regards to further contraband being located in the vehicle?
Yes, ma'am, he did.
Okay. Did you locate the contraband where Mr. Wren said it would be in the jail phone calls?
Yes, ma'am, we did.
I do not have any further questions. Judge, I would like to introduce certified copies of each of these charges that are pending.
All right. Make those as, I guess that's Exhibit 1 to this hearing. Mr. Baker, you may cross-examine.
When you got on scene?
I'm sorry, sir, I couldn't hear you.
Was Mr. Wren already detained when you got on scene?
Yes, sir, he was.
Okay, was he already cuffed up into the car?
He wasn't in the car, no.
Okay, but he was cuffed up?
Yes.
Okay, and who was the initial officer that detained or stopped?
It was Corporal Hollis.
Corporal Hollis. Was it initially a stop for somebody being in a turn lane?
I believe so. It was operating, driving in a turn lane.
Yeah.
I'd have to review his citation for that matter.
Right. Do you have any indication what would correlate a stop for being in a turn lane to a search?
The positive alert to the canine for the vehicle is why we searched.
When did the K-9 arrive? At what time? How long transpired?
I don't know. I'd have to look at the CAD card if it's on there. I couldn't tell you.
It could have been more than 15, 20 minutes?
I don't believe it would have been that long, but
But it could have been.
I can attest to that.
Okay. And now you said that there was some, you kind of danced around. There was a phone call saying there was something that would indicate that there was contraband in the vehicle.
Correct.
Was there a statement on that phone by another party that indicated that?
That there was narcotics inside the vehicle from.
Right.
I'm trying to figure out, so are
Yeah,
you
who
saying,
made
are
the
you saying your
statement?
client didn't say that the narcotics were in the vehicle?
I'm not saying, I'm asking. Who said that on the phone? Was it Mr. Wren or the other party that was calling into the jail?
Mr. Wren was making outgoing calls.
All right, well, which party made the spoken statement that indicated there was contraband there? The other party that he had called or Mr. Wren?
Your client did.
All right, but you don't recall what he says. Is that a fair statement?
Directly, like in quotes, every single word, I do not.
All right, and you would agree that that vehicle that you stopped didn't belong to Mr. Wren, correct?
I don't believe it did.
It didn't. And at what time frame did those narcotics get in that vehicle? Before or after Mr. Wren obtained possession of that vehicle?
I can't attest to that. It was, once him and the other female were taken to jail, it was taken to a secured tow lot.
All right, okay, now, so there's a female there on the scene at the time also? How much of these drugs were hers? Couldn't tell. I'm not getting a lot of answers where a minute ago, the DA was picturing this, that Mr. Wren is on, it kind of insinuates that this is his car and he's got dominion over it. And all these drugs are his. But now I've got a third party and no ownership of the car. Would you agree that that begins to be suspect of who those drugs belong to?
I have an answer for you.
Well, when the drug task force come out, are they tasked with investigating this type of crime?
Sometimes they are.
So they don't investigate these crimes?
They do investigate narcotics crimes, but I can't attest to what they do.
So they don't care who actually owns these drugs, just whose vehicle we find it in?
Can't attest to what they do.
Outside the scope and argumentative. Sustain the objection.
Okay. No further questions, Judge?
Anything further for this officer? Thank you. You may step down. You have any other witnesses? Any rebuttal proof that you wish to offer, Mr. Baker? You wish to be heard in argument?
Legislature's already laid out the remedy for this, and that remedy's been met. If you heard Mr. Wren testify, his bound was doubled on the new charges. That's exactly what 11-148 says. If you're out on bail, charged with the commission of crime while free on bail, remedy isn't, oh, I'm snatching your bail. The remedy is to double the bail, and that's exactly what happened here. And instead of the DA's office following the procedure that the legislature laid out for this, we want to revoke bail on top of that. I disagree that the bail should have been revoked at a minimum. There could have been some additional provisions as the statute allows. You could have put an ankle monitor on him for drug use or scram or whatever we needed to do. For example, we have a whole section for DUIs. If you get a DUI while out on a DUI, they don't say, okay, your bail's gone. Double the bail and add these conditions is the first line of remedy. So now what the state wants to do is you've caught a new charge. One of the charges, we don't even know who called it in or what's, it's a traffic stop. The testimony is from an officer that I don't know who owned, it's not Mr. Wren's car. I don't know whose the drugs is. There's now another party in the car. And okay, now I want him to go to jail because I automatically say, this is the conclusion. Because I am the police, found this car that doesn't belong to the driver. I don't know who owns the drugs. There's another party in there, but because it's Mr. Wren, he's guilty. It's all his. That's the proof. That is absolutely the proof you just got here, Judge, which is the reason why we don't allow the government to say, okay, I'm going to get you a bail. We're all guaranteed bail in this country to protect from strong-handed tactics of the government. Because the fear is exactly as the legislature put here, is that the government wanted to lock you up. They know that, oh, he's going to get granted a bail, but if I go get another petty charge on somebody, whether it's legit or not, I'll just revoke his bail. I've got him. He's in jail. And that's exactly what the state wants to do here. The remedy is to set another bail and let Mr. Wren flesh out, one, the constitutionality of these stops, who owns the drugs, and so forth. When you get back to the Smoothie King, we don't have any 608 knowledge. I don't know any firsthand knowledge here about the stop, all of that stuff. We don't even know the caller. And I think the court can take judicial opinion a judicial notice of, I mean, there's, I think it's Florida versus JL, where the case where the Supreme Court ruled on an anonymous caller with a black man with a gun. Police shows up in the parking lot of an apartment complex, comes into that complex, grabs the first black man I see and starts searching him. Supreme Court says, oh no, it don't work that way. You gotta have some type of independent corroborating evidence before you just start violating constitutional rights. As far as I know, that's what happened at Smoothie King. So the government wants you just to assume there are facts in the evidence, such as, okay, I got a felony conviction at 15, which I find implausible, but they're presenting these evidence unchallenged because they know, okay, well, unchallenged, but I can still get the citizen's bail revoked and incarcerated because it's John Wren, because we've already established that we're just saying it's his because it's John Wren. Looking at the objective facts in the case from what we know or heard of, you can't conclude that. I'd ask for the bail to be reinstated, Judge.
Judge, the state filed a motion to revoke Mr. Wren's bond on April the 16th, giving notice to his attorney, Olin Baker. On April the 27th, in front of Judge Turnbow, his bond was revoked due to the new offenses that took place on April the 14th. Note, Judge, that Mr. Wren was not present on April 27th when his bond was revoked. However, on the afternoon of April 27th, he was arrested by Officer Jake Brake with new drugs and a suitcase in his car, or suitcases in his car. The next day, or on that date, he makes statements that indicate that there are additional drugs in the car in which a search warrant is executed and additional drugs are located in the car. You heard evidence, Judge, of the original offense on April 14th that was the basis of my original motion to revoke. However, Judge, he has then committed new crimes since that time and that you've heard evidence on today. So, Judge, here he is, charged with before the court originally on the 2025 CR 120 with possession with intent to sell or deliver cocaine, possession of a handgun by a convicted felon, possession with intent to sell or deliver fentanyl, drug paraphernalia, all of which was occurred on May 9th of 2025, and he is set for trial in that case, Judge. So here we are out on bond. Mr. Wren is charged not once, not twice, but 3 separate times with 3 separate different offenses involving drugs, guns, and also a stolen gun. Mr. Wren agreed with the questions that Your Honor asked, that he did in fact have multiple felony convictions, and the state has filed notice of enhancement of 13 prior felony convictions. Mr. Wren does not need to be out on bond. For the safety of the public, in new crimes being committed, I would ask that his bond remain revoked. Thank you.
This court respectfully disagrees with Mr. Baker's argument that this case is controlled by 4011-148 because that statute is a person that says, the title of it is bail for a defendant charged with commission of a crime while free on bail. But when you read the language of that statute, subsection A says if a defendant has been released pursuant to 4011-118 or 4011-116, then that statute applies about doubling the normal amount of the bond. What is 4011-115? 4011-115 is releasing someone on an unsecured bond or own recognizance. So when the statute applies, it applies to double the normal bond if someone commits a crime when they've been released on an own recognizance bond or with an own OR bond that contains certain conditions. So this court does not find that 4011-148, as Mr. Baker says, is the controlling statute. Instead, we are controlled by 4011-1. I've got to get back to it. 4011, which has to do with the revocation of a bond while a person commits a new offense while on bond. And that statute, again, as I've cited several times today, is 4011-141. 4011-141 states the following. If after the defendant is released upon personal recognizance, an unsecured personal appearance bond, or any other bond approved by the court, the defendant violates a condition of release, is charged with an offense committed during the defendant's release, or engages in conduct which results in the obstruction of orderly and expeditious progress of the trial or other proceedings, then the court may revoke and terminate the defendant's bond and order the defendant to be held without bail pending trial without release during the trial. And this court went over the prior record of the defendant because his credibility on this issue is a matter for the court to consider as well. And this court is of the opinion that Mr. Wren was either incapable of remembering all of his prior convictions or was less than forthcoming and credible with the court as a witness. This court is considering the matter to reinstate the bond based on the fact that it's essentially asking me to revisit the court's ruling by Judge Turnbull on revoking the bond. And this court is of the opinion that Judge Turnbull made the correct decision at that time. And this court affirms that decision and continues to order that the bond of the defendant in this case be revoked and that he be held pending the trial based upon the commission of new offenses or being charged with new offenses, and further based upon the testimonial evidence that was introduced from the two officers that testified here about what they themselves saw and observed of Mr. Wren's. Mr. Baker may argue at trial that the ownership of the drugs and so forth was not something that could be proven, but for purposes of the bail hearing, the court does find that there's credible evidence that Mr. Wren was engaging in criminal conduct and that he was engaged in possession of drugs and possession of a firearm, more than one firearm, when that was illegal for him. Based upon those facts, the court finds that the bond revocation should remain in place. That's the judgment of the court. Mr. Wren will be held in custody until his trial. Mr. Wren's case set for trial? Do you want to set it for status or trial?
I believe his cases should go to grand jury this time unless they didn't meet the cutoff, because I think they were just maybe bound over last week. So he'll either go to grand jury in June or at the latest in July. So I would just ask maybe for a September status date so they can all join together.
I got me in a pickle. I haven't been retained, obviously, since he's in jail on these new charges, so I can't.
Well, I thought you were his lawyer. You've acted like his lawyer.
Only for the bail issue.
I mean, you, is you is or is you ain't, as they say.
Exactly.
Well, let's go ahead and set it for status on the June 23rd, I'm sorry, September 23rd date. And that'll give you time to determine whether or not you is or ain't. So. Mr. Atchison, you have something?
Judge, can I approach?
Yeah. I thought that was one of those things where you were just saying it while you walked up there. Who do we have left? Rodrigo Flores.
Judge, this is Mr. Rodrigo Flores. He is charged in 25 CR 256. We've reached an agreement with the state in which Mr. Flores would like to enter a no-low contendere plea. He would enter a plea to count 1, which is DUI second offense. Receive a sentence of 1129 to serve at 75%. That's day for day on the 75. Count 2 through 6 would be nollied in settlement. Count 7, he would enter a plea on vandalism, 60 to 250,000, be felony. That's 8 years suspended to probation consecutive to 1, 8, and 9. And I'll explain that here in a second. Count 8, he'd enter a plea on 1 count of felony retaliation for past actions. That's an E felony. Receive a year to serve at range 1, 30% concurrent to the count 1. In count 9, attempted assault on a first responder. It's an A misdemeanor. Receive a sentence of 1 year to serve at 30%. That's also concurrent to count 1. And as a condition, we're going to need a restitution hearing set to determine the exact amount of damage. I think right now we're pretty much aware of 56,000 in damage, but it's higher than that. Loss of license for 2 years. Mr. Flores will pay a $600 fine and court cost, and if he wants to continue to maintain his restricted license, he'll need an interlock. And he's going to report to jail on 6/26/26 at 6 p.m. And the requirement is probation reporting will be in person. I think that's, and I have the jail credits. I believe that is 10 days, Judge. I don't remember the exact dates, but he has 10 days of pretrial jail credits.
Because he's going to serve 1129 at 75% release eligibility day for day.
That is correct, Judge.
All right, Mr. Flores, raise your right hand. Let's place you under oath. Step up to the microphone and state your full name.
I'm Rodrigo Flores.
Mr. Flores, you are here today charged with a multi-count indictment. You've heard your lawyer go over what the agreement is, but have you seen or been shown a copy of the charges? Talked them over with Mr. Baker and discuss with him the range of punishment you're facing as well as any possible defenses you might have.
Yes.
Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
You understand that a plea of no contest means that you are not going to admit you did anything wrong, but you're not going to deny or contest the state's evidence, and they will tell me what their evidence would be at trial, and I'll use that evidence to find you guilty. You understand that?
Yes, sir.
Do you understand, however, that you have a right to a speedy and public trial by jury, and you would have the right to have a lawyer to represent you and could have one appointed if you cannot afford one?
Yes, sir.
You understand at trial you'd be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict will have to be unanimous before you could be convicted of anything.
Yes, sir.
Do you understand that if you went to trial, you and Mr. Baker could confront and cross-examine all witnesses the state called to testify, and you could bring in your own witnesses by use of a subpoena?
Yes, sir.
Do you understand that you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that judgment and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal? All I'm going to do is approve the agreement your lawyer has worked out.
Yes, sir.
You understand that's going to result in a number of convictions, including driving under the influence, that will be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime.
Yes, sir.
I've been handed a document called a Notice of DUI Punishment that purports to bear your signature. Is that your signature on that document?
Yes, sir.
Did you and Mr. Baker go over it? Do you feel like you fully understand all of the enhancement provisions of the law set forth on this document?
Yes, sir.
All right, is your decision today to plead no contest, is that voluntary on your part?
Yes.
Anybody forcing you to do this against your will?
No.
You understand I can't accept your plea unless I'm satisfied there are facts to support a finding of guilt?
Yes.
Then I want you to listen as the state tells me what their evidence would be if this case went to trial.
Your Honor, if the state would go to trial, it would show that on or about October the 18th, 2025, officers with Dickson Police received notice of a security alarm going off at 220 Tensco Drive in Dickson, operating as Sewing Parts Online. Officers arrived and found the defendant, Rodrigo Flores, on scene with his vehicle. Officers learned through the investigation that Mr. Flores drove his vehicle into the building multiple times in different areas, causing serious damage at an amount greater than $60,000. Mr. Flores showed signs of impairment and told officers, quote, "just get me," end quote, indicating he had done something wrong. Mr. Flores gave inconsistent statements as to whether he was in a wreck or not before finally admitting to being in such. Mr. Flores suddenly became aggressive with Officer Salas, at one point threatening to hit him. Officers took Mr. Flores into custody where he fought Officer Slack, which is the basis of attempted assault on a first responder. Later on, Mr. Flores threatened to kill the officers for their past actions of arresting him. Mr. Flores did urinate on himself during this time as well. Mr. Flores refused to provide a sample of his blood for chemical testing where a warrant for his blood was secured. Mr. Flores did have a BAC of .276, about 3.5 times the legal limit. These actions did occur in Dickson County, Your Honor. And this is, for the record, a DUI second, but since he's serving that's the basis of the 2 years of taking his license as well as the $600 fine and cost, it is his second.
All right. Mr. Flores, you understand that's what the state would try to prove if this case went to trial.
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
You feel like Mr. Baker's done a good job of representing you competently?
Yes.
Mr. Baker, do you know of any reason you should not enter this case?
I do not, Judge.
Anything further from the state?
Your Honor, just to note, we are providing Mr. Flores a grace period of 30 days to get his affairs in order. And if he does not report for this 9 months to serve, it could be a basis the state believes of violating his probation for a full sentence of 9 years, and it could be a felony failure to appear as well. So just for the record, if he does not report, that could happen.
All right. Then Rodrigo Flores in docket number 2025 CR 256, upon your plea of no contest to count one, I find you guilty, sentence you to 11 months and 29 days in a county jail to serve at 75% release eligibility for a day for day, which equates to a 9-month sentence of day for day. Your license to drive is suspended for a period of 2 years. You're ordered to pay a $600 fine and cost. You must obtain an interlock for your vehicle before you can get restricted license. The vandalism charge on count 7, you're found guilty, sentenced to 8 years in the Tennessee Department of Corrections, suspended to probation. That will be consecutive to counts 1 and 8 and 9. Count 8, you're found guilty of retaliation for past actions, sentenced to 1 year to serve as a range 1 offender concurrent to count 1. Count 9, you're found guilty of attempted assault, sentenced to 11 months and 29 days in the county jail to serve at 75% release eligibility day for day. That will be concurrent to count 1, and a restitution hearing will be set if necessary. He must report to the jail on or before June 26, 2026, 6 p.m. And as was indicated, your failure to report on that date, you're now on probation. You commit a new crime, you violate the law in driving, you do anything that's violating the law, then you will go to prison for 9 years rather than serve 1 year. You understand that?
Sure.
You must report to probation in person. He'll need to see the probation department. So, all right. We have anybody else back there? He wants to serve his time. Pardon? Whose lawyer, who is this lawyer? Public defender?
He's aware, Your Honor.
What is it? Well, I mean, we played him on a DUI 4th.
I think he'd rather just flatten his sentence and serve the whole year, put it into effect for a year to serve as the E felony rather than doing probation. That's what Mr. Talbot indicated to me, and
Bring out Mr. Dorman and round up Mr. Talbot. So we now have 5 or 6 things set tomorrow. And we're doing, does that include the Houston County Zoom? Oh, well, don't say anything else, because I do have to leave at noon. So.
Your Honor, this is Mr. Dorman again. He advised me that he would like to amend his plea agreement. There's no opposition from the state on this. He requests that he be allowed to amend his plea to where, rather than going on probation, he will instead have his sentence of 1 year to serve with the Tennessee Department of Corrections. He has decided that that is better for him.
All right, Mr. Dorman, raise your right hand. Let's place you under oath. Mr. Talbot, I'm going to allow you to put on the record what it is he's requesting.
Yes, Your Honor. So Mr. Dorman was previously, he had settled his case by entering an agreement for him to have a 1-year TDOC suspended to probation, but for 150 days to serve in jail. And that was going to be a 30% release eligibility sentence, so standard release eligibility, range 1. The only change he wishes to make is that the probation part be eliminated. He does not want to undertake probation. I've discussed this with him. He thinks it would be better to simply have the sentence in effect with all the standard terms, 30% release eligibility. Of course, he must serve the 150 days first, which is mandatory under the statute, before any consideration of his parole on that sentence. I've explained all of that to Mr. Dorman, and he thinks that that's what's best for him.
All right, Mr. Dorman, you understand that I can amend your plea to amend the sentence that I imposed to, instead of requiring you to serve 150 days in jail and then go on probation, that I can order that you serve a simple 1 year in jail. Do you understand that?
Yes, sir.
And that's what you're asking me to do, is that correct?
Yes, sir.
All right, then I will amend the judgment in this case to provide that he will serve 1 year, and that will.
The only thing I would make sure to say on the record is that the minimum time is 150 days. Even if he's 2 for 1 year, do credits.
He's got to do at least 150 days, but he can do the entire year or whatever whatever the Department of Corrections deems to be appropriate for that sentence. So.
My experience was a 1 or 2 year sentence. Those are permanent release sentences. So once he gets back to it, of course, he can try to work 2 for 1, whatever else with them. That's fine.
All right.
Once he does at least 150.
Then that will be the judgment of the court. Thank you.
Thank you, Your Honor.
Thank you.
So we are concluded until tomorrow morning at 9 o'clock.
Yes, sir. On, if I may, Your Honor, on the Nicholas Creech matter, I spoke with Mr. Creech. He does not want to proceed on that motion tomorrow, so we don't need to do that, if that's okay with the court. I'm going to file a motion for a bond reduction on his behalf in his 2 cases that my office is representing him on.
Thank you for letting me know. So we're back down to 5 things.